sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
I'm going to hang up on you, Rafael, and then we'll call you right back, okay?
No worries, Your Honor. I'll be on standby.
All right. Okay. Which cases are there?
All right. Your Honor, Audi Ochoa, this is Scott Syverson on behalf of Mr. Ochoa, O-C-H-O-A. Oldie's first name.
Ochoa? You also have Lorena Beaujolais? Okay, so let's start with Lorena Beaujolais. Or is that, who's that?
This is Mr. Ochoa.
Okay, we'll start with Ochoa. That's right. All right, good morning, sir. Your name and date of birth, please.
My name is Audi Ochoa. I was born 7/2/92.
All right, Mr. Ochoa. You're here on 8 counts. I've reviewed the affidavit. I do find there is probable cause for those charges. Let me tell you what they are. First one is cocaine possession. Second one is marijuana possession. Third one is drug equipment possession. To use to possess or manufacture paraphernalia to transport drugs. Fourth one is cocaine, sale of cocaine. Fifth one is trafficking cocaine. Sixth one is drug possession, controlled substance without a prescription. Seventh one is drug possession. And the eighth one is drugs, health or safety, manufacturing, sale, possession, altered, misbranded, unfit. I've reviewed the affidavit. I do find there is probable cause for those charges. Do you want to be heard on bond, Mr. Syverson, or?
Yes, Your Honor. The pre-sentence amounts exceed $200,000, I believe. And we're looking to see if we can get that lowered. The basis for the stop is a seatbelt violation. I understand that the offenses are numerous and serious. This is a stop based on a seatbelt violation, of which Mr. Ochoa is a passenger. He's a lifelong resident of Florida. Is that right, Mr. Ochoa?
Yes, sir.
He resides in Dade County.
Yes, sir.
He has employment there. I'm asking the court to consider surrendering the passports, any restrictions, home confinement, so we can put the bail up, and if any necessary hearing that would have regarding any hold on that.
Mr. Rivers?
First degree charge, that is.
Mr. Rivers?
Alethea Rivers for the state of Florida. The state would ask that the bond stay as it is in these cases.
What's Treehouse Miami? What is Treehouse Miami?
It's a club. I'm a partner at a club, sir, in South Beach.
I'm going to stay the bonds. I'm also going to order you not to possess any controlled substance, drugs, or other controlled substance without a prescription.
right, no other restrictions, Your Honor?
No, no.
Okay, and for the amount, did I say the correct amount? Is it 234,000,
2,
Ms. Rivers?
18, 118, 118, 34. Yep. All right. Thank you, sir. Make it work. Is a companion case.
Yes, thank you, Your Honor. Scott Syverson on behalf of Lorena Beaujolais.
So, man, just give me your name and date of birth, please.
Lorena Beaujolais. Lorena Beaujolais, May 3rd, 1991.
Okay. Mr. Syverson.
Your Honor, Ms. Beaujolais was the driver, and the subject that we just had was Mr. Ochoa. She was pulled over and allegedly on a seatbelt violation from the right side. The same charges as Mr. Ochoa faces and the same bond amount. She is a owner of properties. She resides both in Costa Rica and in Miami-Dade County. I've asked for the court to reduce the bond, no priors, but we'll surrender the passport if the court is concerned about that, obviously.
All right. State.
Alethea Rivers for the state of Florida. The state would ask that the defendant's bond be stayed and that she surrender her passport to Costa Rica.
Hold on a second. Your Honor, she travels back and forth to Costa Rica. She has a business there. It was her father's. Her father had passed, and that probate is near done, from what I understand. And to the extent that there be any need to travel, for that purpose, it would be arranged and planned, nothing spontaneous. Right. Okay.
What is the business in Costa Rica?
The court's asking a question.
What's the business in
Sorry,
Costa
go ahead.
Rica? What's the business in Costa Rica?
A bunch of property management and pay by the hour parking garage.
What I was getting at, Your Honor, is the necessity to finish the probate proceeding in her father's estate. It's not done. It would be a final hearing of it. She's the heir of it, and the
president now.
sorry.
I'll stay the bond. In terms of the travel, PTR, can she clear like itineraries with you? Like, can I order y'all to do that?
No, she doesn't qualify for PTR.
Okay, so you can't do anything on it?
No.
I won't make you turn over your passport, so, but I'm gonna ask that you all inform the state anytime she's traveling
Yes, Your Honor.
out of the country.
No other conditions, Your Honor, the conditions of no possession?
No possession.
Yes.
Yeah. All right.
Thank you, Your Honor. Thank you, Ms. Rivers.
Thank you. Now, can I use this one for the interpreter now? I have to use the other one. I'm gonna use this one. We're gonna risk it.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn, Judge.
All right. First one I have is Josue Alvarado? The victim is an interpreter as well? Okay. Give me 1 second. Are these not, oh, these aren't in order? Oh, it's paper clip too. No, you're good. All right. This is case 22MM290.
Thank you, Your Honor.
All right. Morning, sir. Your name and date of birth, please.
Buenos días, caballeros. ¿Me puede dar su nombre y su fecha de nacimiento, por favor?
Josue Alvarado Perez, el 12 de marzo de 2004.
Josue Alvarado Perez, 12th of March, 2004.
Okay. Sir, I'm sorry. We didn't finish getting appearances. Appearance.
Dominique Cunningham from the Office of the Public Defender.
All right. I'm going to appoint Ms. Cunningham in her office to represent you in this matter.
Voy a designar la licenciada Cunningham y las oficinas de ellos para que la representen a usted.
All right, so you're here on 1 count of battery.
Usted se encuentra aquí, caballero, en el día de hoy por un cargo de agresión.
Review the affidavit. I find there is probable cause for that charge.
He revisado la affidavit y determino que existe motivo fundado para ese cargo.
Good morning, sir.
Buenos días, caballero.
Is there a mic in there or there's no mic in there?
It's right there.
Okay, it kind of blended into his shirt. Can you make sure you speak into that mic, please?
Señor, asegúrese de hablar cerquita del micrófono para que se le pueda escuchar, caballero.
Okay.
Okay, sorry, what's your name?
¿Cómo se llama usted?
Carlos Alvarado Pérez.
Carlos Alvarado Pérez.
Okay, and you are the victim in this case?
Y usted es la víctima en este caso.
Ajá. Sí.
All right, can you raise your right hand for me, please?
Por favor, levante su mano derecha.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, nothing but the truth? So help you God.
Usted jura solemnemente o afirma que el testimonio que usted dará en este caso será la verdad, toda la verdad, solamente la verdad de Dios.
Acepto.
I'm sorry, Your Honor, the interpreter's having
Yeah,
difficulty.
you gotta.
The victim. Señor, necesito que usted alce la voz, por favor.
Okay, sí, acepto.
Yes, okay, I accept.
Okay. You can put your hand down.
¿Puede bajar la mano?
Okay. Sir, I'm going to ask you a few questions about the terms of release.
Señor, le voy a hacer unas preguntas a usted referente a las condiciones de libertad.
So I don't want to hear about the crime or he didn't do it or anything like that.
Y por lo tanto no quiero escuchar detalles sobre el delito, o si lo hizo o no lo hizo.
Sí.
My first question is,
Yes.
do you want to have contact with your brother?
Mi primer pregunta para usted, ¿usted desea trato con su hermano?
Sí.
Yes.
Are you scared of him?
¿Usted lo teme a él?
No.
No.
If something like this were to happen, would you call law enforcement?
Si algo semejante sucediera, ¿usted llamaría a las autoridades?
Sí.
Yes.
Do you all live together?
¿Ustedes viven juntos?
Sí.
Yes.
Do you want him to return to your house?
¿Usted desea que él regrese a su casa?
Sí.
Yes.
Are you scared of him?
¿Usted lo teme a él?
No.
No.
Mr. Rivers?
Alethea Rivers
Rivers?
for the state of Florida. Sir, have you and your brother been involved in an incident like this before?
Caballero, ¿usted y su hermano han estado involucrados en un incidente semejante anteriormente?
No.
No.
No further questions.
Okay.
No tengo más preguntas.
None from the defense, Your Honor.
No tenemos preguntas por parte de la defensa.
And does he qualify for PTO?
No, Your Honor, due to legal status.
No reúne requisitos para libertad provisional debido a su estado legal.
I'm going to set your bond at $500.
Voy a programar su fianza en $500.
I'm going to order you to have no hostile contact with the victim.
Se le ordena que no tenga trato hostil con la víctima.
Not to consume any alcohol or other drugs or prescriptions other drugs or controlled substance without a valid prescription.
Se le ordena que no ingiera, que no consuma alcohol, drogas o medicamentos a que no sea que tenga receta válida.
And no weapons of any kind.
Y no puede portar armas de ninguna índole.
Okay. Thank you, sir. And thank you,
Gracias,
sir.
caballero.
Gracias.
Y gracias a usted también, señor.
Domingo Toma.
And Your Honor, if there isn't a victim present, if we could respectfully request that we use the headphones?
Yes, Your Honor. He had a victim in Spanish.
Okay, sure. So, want to put on the headphones? Is that what we're, or we put on the headphones for the victims?
No, usually only when they don't have a victim that needs Spanish.
Oh, we have victims, okay, I'm sorry.
We have a victim as well? Okay, Your Honor, I just wanted to clarify. Thank you.
Thank you. So the victims need the interpreter as well? Okay. All right. This is a 22 3570.
Thank you, Your Honor. And I'm sorry, could you kindly confirm the name of the defendant one more time, please?
Domingo, like Sunday, Toma, like drinks.
Thank you, Your Honor.
Sunday drinks. Okay. Sir, your name and date of birth, please.
Caballero, su nombre y su fecha de nacimiento, por favor.
Domingo Ernesto Toma Cabinal, 2 de febrero de 1990.
Domingo Ernesto Toma Carbinal, 2nd of February, 1990.
I have here that your birthday is February 6th.
Aquí indica que su fecha de nacimiento es el 6 de febrero.
Sí, 6 de febrero. Perdón.
Yes, the 6th of February. I'm sorry.
Okay. All right, I'm going to appoint Ms. Cunningham and her office to represent you on this matter.
Voy a designar a la licenciada Cunningham y su bufete para que la representen a usted en este asunto.
Okay. You're here on one count of battery.
Usted se encuentra aquí por un cargo de agresión.
I've reviewed the affidavit. I find there is probable cause for that charge.
He revisado la affidavit y determino que existe un motivo fundado para ese cargo.
Hello.
Buenas.
Buenos días.
All right.
Good morning.
What's your name?
¿Y usted cómo se llama?
María Abigail Chamay Pérez.
Clarification, Your Honor. Despacito, por favor. María.
Abigail Chamay Pérez.
María Abigail Chamay Pérez.
And who's that with you?
¿Quién le acompaña?
My name is Judith Schmidt. She's a minor, so I'm just accompanying her.
Yo soy Judith Schmidt. Ella es menor de edad y por lo tanto la estoy acompañando a ella.
Okay. What's her birthday?
¿Cuál es la fecha de nacimiento de ella?
18 de julio de 2004.
The 18th of July, 2004.
I mean, minors can't testify without a motion.
Los menores de edad no pueden atestiguar a que no sea que se entable un pedimento.
Unless everybody wants to stipulate.
A que no sea que todos quieren estipular.
Your Honor, I'm fine with it.
Señora, yo estoy de acuerdo.
That was Ms. Cunningham.
No
Eso
objection
fue la,
from the
por
state.
parte. Y la fiscalía no tiene objeción ni la defensa tiene objeción.
Okay. Let me ask you a couple preliminary questions so I can deem you competent to testify.
Le tengo que hacer unas preguntas preliminarias para determinar si usted es competente para atestiguar.
Do you know the difference between the truth and a lie?
¿Sabes la diferencia entre la verdad y una mentira?
Sí.
Yes.
Okay. So why is telling the truth important?
¿Por qué es importante decir la verdad?
Sí.
Yes.
Why?
¿Por qué?
Don't help her.
¿Cómo dijo? Perdón.
What did you say? I'm sorry.
Why is it important to tell the truth?
¿Por qué es importante decir la verdad?
It's a simple but important question about
Es una
life in
pregunta
general.
Es una pregunta simple pero muy importante sobre la vida en general.
Para que no me vuelva a pasar nada más.
So that nothing else will happen to me.
Okay. Are you of normal intelligence for your age?
¿Tú tienes una inteligencia promedio para tu edad?
Sí.
Yes.
Have you finished school?
¿Terminaste la escuela?
Ahorita estoy estudiando.
I'm still going to school right now.
Okay. Do you read on your grade level?
¿Tú lees en el nivel escolar tuyo adecuado?
¿En donde estoy estudiando ahora o allá en Guatemala?
You mean here where I'm going to school or back in Guatemala?
In Guatemala, in your native language.
¿En Guatemala, en tu idioma nativo?
Sí.
Yes.
Okay, so court will find the witness is competent to testify.
El tribunal determina que el testigo es competente para poder atestiguar.
Okay. So what is your relationship to Mr. Toma?
¿Qué relación tienes al señor Toma?
Es el papá de mi bebé.
He's the father of my baby.
Oh, okay. Do you wish to have contact with him?
¿Deseas tener trato con él?
Sí.
Yes.
You seem a little scared.
Pareces estar un poco asustada.
No, no estoy asustada, estoy bien.
No, I'm not scared, I'm fine.
Are you scared of him?
¿Tú lo temes a él?
No.
No.
How old is your child?
¿Qué edad tiene tu criatura?
Tiene 4 meses.
4 months old.
How long have you been in this country?
¿Cuánto tiempo llevas en este país?
Desde el 2019 entré aquí en Estados Unidos.
I came to the United States in 2019.
So you met him here?
¿Lo conociste aquí?
Ya teníamos comunicación cuando estaba en Guatemala.
We were already communicating when I was in Guatemala.
Do you live together?
¿Ustedes viven juntos?
Sí.
Yes.
Okay. State?
¿Fiscalía?
Sí.
Yes.
Would you feel comfortable living with him if he returned home?
¿Usted se sentiría cómoda viviendo con él si él regresara al hogar?
Sí, pero nada más que hay que poner condiciones en la casa para que no vuelva a pasar un problema.
Yes, but there have to be some conditions imposed so there won't be any problems at home.
Has there been previous problems at home with him?
¿Han habido problemas en el hogar anteriormente con él?
No.
No.
Has he ever been aggressive with you?
¿En algún otro momento él ha sido agresivo con usted?
No, es la primera
No.
vez que pasó.
It's the first time this happens.
And when you say problems at home, what do you mean by that?
Y cuando usted dice problemas en la casa, ¿a qué se refiere?
Es cuando si problemas es una discusión grande, eso sí es un problema.
Well, problems are like a serious argument. That's a problem.
And do you become afraid of him when you have these serious arguments?
Cuando tienen estas discusiones graves, ¿usted lo teme a él?
No.
No.
No further questions.
No tengo más preguntas.
Ms. Cunningham.
Ma'am,
Mr.
who
Cunningham?
owns the home that you live in?
Señorita, ¿quién es el propietario del hogar donde usted vive?
¿Quién es el dueño de la propiedad donde vivimos?
Who's the owner of the property we live in?
Yes.
Sí.
La señora se llama Mónica, pero no sé cuál es su apellido.
The lady's name is Monica, but I don't know her last name.
And who pays the rent for this place?
¿Y quién paga el alquiler por este lugar?
Domingo Ernesto.
Domingo Ernesto.
Would it be a hardship for you to take care of your child without Mr. Toma?
¿Sería una adversidad o una dificultad para usted tener que cuidar a su hijo sin tener al señor Toma?
No.
No.
No further questions, Your Honor, but I would like to be heard on the conditions of release.
No tengo más preguntas, su señoría, pero si me pudiera escuchar sobre las condiciones de libertad.
You may proceed.
Adelante.
Your Honor, Mr. Toma does qualify for pretrial release, so we would ask for a monetary bond as well as pretrial release conditions to ensure that there are no issues. Nothing further is happening at home.
Su señoría, pedimos libertad provisional con unas condiciones monetarias para asegurarnos que nada más fuera a suceder en el hogar.
Your Honor, they do have a child in common, so we would ask for there to be no hostile contact imposed as well.
Y como tienen una criatura en común, pedimos que se le imponga el requerimiento de un trato sin hostilidad.
Okay, no. No. Allowing contact would be perpetuating a continuing crime. She's 17 years old, he's 32. In order no contact, legally, he actually has no rights. 744-301 says mother of an unborn child is the only one who has custodial parental rights until a court adjudicates it, which it hasn't been adjudicated. And so, no.
I'm sorry.
Sorry.
My apologies, Your Honor.
I went on a rant
Okay.
there.
No worries, Your Honor. No, no lo voy a permitir. Él tiene 32, ella es 17, no voy a seguir continuando esta situación. Él no tiene derechos a la criatura. La única persona bajo el estatuto 744.301 que tiene el derecho sería la madre de una criatura no nacida.
When they're unmarried.
Cuando no están casados.
So I will release him on $50 en PTR.
Lo voy a liberar con una fianza de $50 y condiciones de libertad provisional.
No contact.
Lo voy a prohibir el trato.
I'll do no weapons.
No se le permitirá portar armas.
No controlled substance.
No puede ingerir sustancias ilícitas.
To maintain separate residence with a one-time return to retrieve personal belongings.
No puede regresar, tiene que mantener a una residencia separada, puede regresar una sola vez acompañado de un agente del orden público para recopilar sus pertenencias personales.
Thank you, guys.
Gracias.
Thomas Santiago Heroes. And this is 22 CF 6087.
Thank you, Your Honor.
I forgot to thank her.
Sí.
All right.
Sí, sí te escucho.
Your Honor, are we?
Your Honor, the interpreter can confirm the defendant is able to hear through the headsets.
Your Honor, if we are appointed, I'd like to waive the reading of the charge.
Sí.
Yes.
All right. Sir, your name and date of birth, please.
Tomás Santiago Quirós, 1 de junio de 1959.
Tomás Santiago Heroes, 1st of June, 1959.
All right. Good afternoon, sir. I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You're here on 2 counts. I have reviewed the arrest affidavit. I do find there is probable cause for those charges. I'm going to set your bond as follows. On count 1, $250,000. On count 2, $2,500. Or do you have no contact with the victim or anybody similar? And that'll be it. All right, thank you, sir.
Gracias.
Abimelette Torres Osorio. And this is 22 CF 6050.
Thank you, Judge.
You. Sir, your name and date of birth.
Abimelette Torres Osorio, 13 de junio del 1983.
Abimelette Torres Osorio, 13th of June, 1983.
Sir, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You're here on 1 count of aggravated assault with a firearm. I reviewed the arrest affidavit. I do find that there is probable cause for that charge. I'm gonna set your bond as follows. I'm gonna set your bond at $50,000. In order you have no weapons of any kind, no contact with the victim or any witnesses, and not to return to the scene. All right. Thank you, sir. Manfredo Orozco Perez. This is 22 CT 888.
Thank you, Your Honor.
All right, sir, your name and date of birth, please.
Manfredo Antulio Orozco Pérez, 3 de junio 1989.
Manfredo Orozco Antonio Perez, 3rd of June, 1989.
Okay, Mr. Perez, I am going to appoint Ms. Cunningham in her office to represent you. You're here on one count of DUI. Is 0.15 or higher or with a person under 18. Reviewed the arrest affidavit. I find that there is probable cause for that charge. I'm going to set your bond at $500. Order you to consume no alcohol, drugs, or other illicit substance without a valid prescription. Also, order you not to operate a motor vehicle without a valid driver's license.
Está bien, muchísimas gracias.
Hold on.
That's fine. Thank you very much.
I'll take no action on the open cases.
Gracias.
Thank you.
All right. Miguel Mandia. All right. Sir, your name and date of birth, please.
Miguel Mantilla López, diciembre 7 del 86.
Miguel Mantia Lopez, 7th of December, 1986.
You're here on case 22MM 3575. I'm going to appoint Ms. Cunningham and her office to represent you. Sorry. You may not have been able to hear me. Oh, you have the headphones on. All right. So I've reviewed the arrest affidavit. I do find there is probable cause on that charge. I'm going to set your bond at $500. Order you not to return to the scene. Does he qualify for?
No, Your Honor.
Your Honor, this is a misdemeanor pleable. Would the court be willing to extend an offer at this time?
State?
The state doesn't have an offer at this time, but the state does not object to the court issuing an offer in this case.
Can you give me a history?
One misdemeanor conviction, battery, resisting arrest, escape, retail theft, violation of controlled substance, criminal misdemeanor, criminal mischief.
Okay, so my offer would be 15 days in county jail and adjudication of guilt, court costs, and restitution. That's my offer.
Your Honor, I'm not sure if he's willing to take it. I don't speak Spanish, so I can't.
I just want to make it clear that's just mine. Nobody's being forced to honor that.
Huh?
Would you like to take that offer, sir? It's 15 days in the orange.
I don't feel comfortable accepting an offer today.
Yes, Your Honor.
The language barrier and all.
Yes, Your Honor.
So, I'll tell you what, if he thinks about it overnight, I'm here all weekend.
Yes,
Your Monday.
Yes, Your Honor.
I won't change it.
Your Honor, what was the bond you said again?
Oh, 500. Thank you. Who is this? Okay. Okay. All right, sir, your name and date of birth, please.
Efraín Caraballo Borrero. Borrero. Fecha de nacimiento, diciembre 28 de 1983.
Efraín Caraballo Borrero, date of birth 28th of December 1983.
Your mother must have had a heck of a Christmas that year.
¿Cómo?
What was that?
Because your mom was about to have you on Christmas Day. So it must have been a tough Christmas that year.
¿Sí?
Yes.
Okay. I'm going to appoint Ms. Cunningham and her office to represent you on this matter.
Your Honor may be heard on probable cause.
You may.
Your Honor, the defense takes the position that there's no probable cause for any of the firearm charges, as there was no firearm found on Mr. Rail. The firearm was found where they claim that he was walking, but no one provided any description of the firearm he was alleged to have had. So the court may find that there was reasonable articulable suspicion that that firearm belonged to him, but there is not PC, which is required to hold him in Orange County Jail on those charges. Your Honor, there's no surveillance or anything. And just to reiterate, there was no description of any weapon that was used.
Does the statute or the law require a description of the weapon?
It does not, Your Honor, but he is being charged with possession of a firearm and the commission of a felony, discharging or possessing or discharging a destructive device, possession of a short barrel gun, which, Your Honor, he wasn't found with a gun. He wasn't seen dropping a gun. There's no description of the weapon. So there's no probable cause to tie that weapon that was found to him.
State. So which charges specifically are you challenging, just to be clear, for the record?
Your Honor, the defense is challenging all of the charges except for the possession of ammunition by a convicted felon, with an understanding that the argument is not as strong as to the aggravated assault for the firearm, and then the possession of a firearm by a convicted felon, but the argument does still stand.
So all of them except count
Possession of,
3?
yes, Your Honor, because the ammunition was found on his person.
Alethea Rivers for the state of Florida. There was a written statement provided by Alberto Luis Martinez, the victim in the case. He did state that he saw the defendant pull out a firearm and the defendant pointed the firearm at him. Also, there is also an independent witness, Carmen Iris Martinez Negron, who stated that she also observed the defendant with an object that looked to be a gun and tried to hit the victim with it as well.
What about where it says, while conducting an incident search to arrest a blue 12-gauge live shot, round?
Yes, Your Honor, that goes to the ammunition.
Gotta read the whole thing.
I think I
Whole
had to
sentence.
read it a
You gotta read
couple
the whole
times.
sentence.
It was jumbled.
Are you still reviewing, Ms. Rivers? Ms. Rivers?
I've read it, Your Honor.
Still reviewing?
I've read it. I read through it. The state would just ask for a 24-hour reset if Your Honor does not find probable cause exists from the affidavit.
And Your Honor, the defense would just like to put on the record, the four corners of the affidavit appear to be complete. There's nothing stating that anything is missing. There's no extraordinary circumstances as to which would provide the state with another 24 hours to review.
They get 48 hours to prove PC, so I'm gonna grant the continuance. Are you here tomorrow, Ms. Rivers?
Yes, Your Honor. I'll be here.
You know, sometimes there's lost communication, and I don't want to just delay giving this man a bond. Okay, what's reset for 24 hours?
Yes, Judge.
Well, there must have been a typo in setting these bonds. The only thing.
Your Honor?
I'm not going to stay these bonds, but I can't change them without finding PC. So, the state's asked for 24 hours. So. You still want 24 hours, right?
Yes, Your Honor, that's correct.
Change them.
Una pregunta.
I have a question.
Ask that young lady standing next to you. I'll plug my ears.
Yo todavía tengo fianza.
Do I still have a bond?
The bonds are as stated, and we will come back tomorrow for us to discuss whether they are going to stay as they are.
And Your Honor, the interpreter can respectfully request the case number for this last defendant, please.
Oh, you can. What's the case number? It's 2022 CF 6042.
Thank you, Your Honor. Does the court require any further assistance from the interpreter at this time?
Is that the last one we have for Spanish? All right. Oh, we're good.
Have a good weekend, Your Honor. Nice talking to you, sir.
You I was gonna say take Monday off, but you know.
I will. Thank you. I'll say
Oh, you will.
authorized it. I'm just going to tell him you authorized it, Judge.
All right. Tell Judge Mandia.
Have a good weekend.
All right, you too. Bye. All right. Is this Mr. Lautu?
Your Honor, he refused.
Okay. So is this Molina?
Your Honor, is the Office of the Public Defender appointed to Mr. Waltu?
Not yet. I mean, he refused.
Will we be appointed to his case?
But do you want to waive?
Yes, Your Honor.
Let's give him another day.
Yes, Your
Usually
Honor.
do it on the second day. I'll ask. So, name and date of birth, please.
Luis Molina,
And your date of birth?
June 19, 1999.
All right, Mr. Molina, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You are here on one count of battery, dating violence. I've reviewed the arrest affidavit. I do find that there is probable cause for that charge. And then you have a second case, which is aggravated assault with a firearm and carrying a concealed weapon. I've reviewed the affidavit. I do find there is probable cause for those charges. On the first case, the dating violence, I'll set your bond at $2,500. On the second case, the aggravated assault count, I'll set at $5,000. On the carrying a concealed weapon, I'll set at $1,000. So your total bond will be, if I'm $8,500, if my math is right. Huh? No, this is Luis Molina. L2 refused. Yeah. And then I'm going to order you to have no contact with the victim, to maintain a separate residence, one-time return with law enforcement, to retrieve personal belongings if you all live together. No weapons of any kind, and that'll be it. All right, thank you. All right, Scott Sanders. Is this one you had a PC on, or is that?
No, Your Honor.
Oh, it's on Scott, sorry. All right, sir, your name and date of birth, please.
Scott Sanders, 9/13/72.
All right. All right, Mr. Sanders, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You're here on 2 counts. First count is battery, domestic violence. Second count is criminal mischief. I've reviewed the arrest affidavit. I do find there is probable cause for those charges. Can I get a history real quick?
Yes, last conviction was June 25th, 2021 for larceny, convictions of robbery, battery, multiple drug possession, burglary, fleeing to elude, arrest charges, multi-drug possessions, aggravated battery, aggravated assault with deadly weapon, and a violation of probation.
I'm going to set your bond on count 1 at $10,000. On count 2 at $500.
Your Honor, I apologize. It's $10,000 on the battery, domestic violence.
Yeah.
And Your Honor, at this time, we'd ask for a lower bond.
No objection from the state.
I'm going to stay my bond at 10.
And what was the bond on the second count, Your
I
Honor?
have 500. All right, I'm going to order no contact with the victim, to maintain separate residence, one-time return with law enforcement, no weapons of any kind. All right, thank you. Michael Taylor.
If you would, Your Honor.
Dwayne Weber.
Yes, sir.
All right, name and date of birth, please.
Dwayne Alfred Philip Weber, 9/27/1968.
All right, Mr. Weber, I'm going to appoint Ms. Cunningham and her office to represent you. You're here on 1 count of petty theft. Reviewed the affidavit. I find there is probable cause for that charge. I'm going to issue you a bond. He doesn't qualify for PTO.
No, Your Honor.
All right, I'm going to set your bond at $250.
Your Honor, does the court have an offer for this case?
Does the state have an offer for this case?
The state has no offer, but the state does not object to the court issuing an offer.
Can I get a history, please?
Yes, no convictions, arrest history, 2 counts of battery, DV, violation of domestic injunction, multi-violation of probation, and out-of-state conviction cocaine.
Offer him an adjudication and 2 days in county jail, 1 day credit. Well, I think that's
2 days credit time.
2 days credit time served. So I'll offer time served and court costs.
Have a moment.
And adjudication.
Your Honor, we'd like to take that offer at this time.
All right, sir, if you can raise your right hand for me, please.
Sorry, he's signing the plea form.
Swear or affirm testimony you're about to give in this case to be the truth, whole truth, nothing but the truth, so help you God?
Not ready.
Is that a yes?
Yes, sir.
Okay. Sir, what's your name and age?
Dwayne Alfred Philip Weber, 53.
All right, how far did you go in school?
Well, around 9th grade, I dropped out, but I went back and got it in
So
2000.
you have your GED?
I got a high school diploma.
Oh, okay. Okay. Sorry, have you ever been treated for mental illness?
More than several times.
I can barely
Yes, I
hear you, I'm
have.
sorry.
Yes.
When?
Recently, it was about 3 weeks ago.
Okay. Are you currently under a doctor's care?
No.
Okay. Are you under the influence of any drugs, alcohol, or other narcotics?
No.
Okay. Any medication you're on?
I do take medication.
Which medications do you take?
I take Seroquel, Vivitrol, and Trazodone. But the lady, last time I talked to that lady, she said I didn't need to be on it anymore, so I think I'm pretty good.
I'm sorry, I can't hear.
I take 3 medications.
Okay. Do any of those affect your ability to understand what's happening?
No.
Your offer is an adjudication of guilt, credit for time served, and then court costs. Okay? You understand those terms?
Yes, sir.
Speak up.
Yes, sir.
Okay. What's the maximum penalty?
This is an M1, maximum penalty would be 365.
And there's no mandatory minimum, blah, blah, blah. You understand the terms of your plea, sir?
Yes, I do.
And Your Honor, for the record, I did quickly go through the plea form with him.
Great, thank you. That was my next question. Was anything promised to you other than the terms of the plea?
No, but when do I have to pay the fees?
I'll tell you.
We'll talk about that in a second. Did anybody promise you anything in exchange for accepting the plea or threaten you in any way?
No.
Okay. You understand that there won't be a trial if you accept a plea?
Right.
And you'd be giving up certain constitutional rights, such as the right to plead not guilty and have a trial by jury,
Right.
Right to have an attorney,
Right.
the right to have the state prove their case against you.
Right.
And you want to proceed with the plea?
Yes, sir.
You're a U.S. citizen?
Yes.
Are you satisfied with the services of your attorney?
Yes, sir.
All right. So to the charge of larceny, petty theft, second degree, first offense, how do you plead?
No contest.
The offer is well, you can plead no, I can still adjudicate him guilty, right?
Yes.
Okay. All right, so I'm going to accept the plea. I'm going to find that the defendant really voluntarily and intelligently waived his right, sorry. I find the defendant knowingly entered the plea and understands the nature of the charges and consequences of the plea. I find the defendant competent, coherent, and alert. And after a review of the arrest affidavit charging document, there's a factual basis for the plea. And I'm going to sentence you to credit time served, adjudicate you guilty, and order you to pay court costs. How much time do you need to pay the court costs?
Whatever you feel is fair.
Your Honor, we'd ask for a full year to pay the court costs.
State?
No objection from the state.
All right, we'll give him a full year to pay the court costs. Let me just, all right, thank you. Tried to demote me there at the bottom. It's county judge. I'm positive the second page, the second chart. I may have gone down to 2,500 on. So I think the total bond was 8,500. Wait, we can just ask them. Can we, sorry, on Mr. Molina's case, what were the bonds I said? That was like the first one of, after the interpreter.
After the interpreter.
2,500 was the bond.
Sorry?
2,500 for Luis Xabrian Molina.
So,
Yes.
on the first one, 2,500. And then on the aggravated assault with firearm, in 2 cases.
Yes, for the aggravated assault with a firearm, for the first count, 2,000. Carrying a concealed weapon, bond was set at 1,000.
2,000?
It was 2,500.
All right, thank you. Sorry about that. All right, sir, your name and date of birth.
Josue Figueroa, March 24th, 1974.
Okay. All right, Ms. Figueroa, I'm going to appoint Ms. Cunningham and her office to represent you in this matter. You're here on one count of alcoholic beverages, open containers. Reviewed the arrest affidavit. I find that there is probable cause. I assume you want an offer?
Yes, Your Honor.
State?
The offer in this case would be an adjudication of guilt, 5 days with credit for time served and court costs.
Your Honor, would the court be willing to do credit time served because this is an open container?
What's the history?
Okay, 8 felonies, 100 misdemeanors, 3 failure to appears, last in 2017. Multi-extension of open container, multi-trespass, multi-drug paraphernalia, extensive petty theft.
I would stay with the state's offer.
Your Honor, we'll take that offer.
All right, sir, raise your right hand for me, please. Solemnly swear or affirm testimony you're about to give in this matter be the truth, whole truth, nothing but the truth, so help you God.
Yes.
All right, give me your name and age, please.
Josue Figueroa,
All right, how far did you go in school, sir?
11th grade.
All right. Have you ever been treated for a mental illness? No?
Nope.
All right. Are you currently under a doctor's care?
Nope.
All right. Are you under the influence of alcohol, narcotics, or any medication? No. State, can you articulate the terms of the plea?
The offer in this case is an adjudication of guilt for the defendant to serve 5 days in the Orange County Jail with credit for time served and to pay court costs.
Is it 365 the max? Or what is this, county ordinance now?
Yes, I believe it's 60.
60. All right, so 60 days maximum sentence. Do you understand the terms of the plea?
Yeah, 5 days, right?
All right, have you had a chance to speak to your attorney about it?
Yes, no.
All right. Were you promised anything other than what you've heard? Anybody force you into your decision?
You gotta speak into the mic.
No, sir.
All right, do you understand that you're giving up the right to a trial, the right to call witnesses, or right to an attorney?
Yes, sir.
All right. And you want to proceed with the offer?
I got how many days now? 2 days in?
Yes.
You do?
I can't go home right now?
No.
No.
5 days, right?
Yeah.
5 days, I'll do the 5 days.
Um, are you satisfied with the services of your attorney?
Yes.
All right. State, can you
Yes,
put a
I am.
can you put a factual basis on, please?
Yes, Your Honor. On May 27, 2022, Officer M. Zark was on bike patrol in the area of 53 North Orange Avenue. While on patrol, he observed a white male, later identified as Nelson Figueroa, sitting down on the public sidewalk up against the above building. Figueroa had a white and red aluminum can placed beside him. The officer immediately recognized the can to be consistent with an alcohol container, specifically past Blue Ribbon beer. Figueroa picked up the can and placed it to his mouth and consumed a portion. The officer approached Figueroa and he immediately started to pour it out on the sidewalk.
All right, so the charge of, is it open containers at the?
Yes, Your Honor.
How do you plead?
I plead guilty. I was drinking a beer and he caught me. Other people sit down there and drink beer.
All right, I'm going to accept the plea. I'm going to find the defendant freely, voluntarily, and intelligently waived his rights. Find the defendant knowingly entered the plea and understands the nature of the charges and the consequences of the plea. I'm going to find him competent, coherent, and alert. And I'm going to find that there is a factual basis for the plea and sentence the defendant according to the plea, which is 5 days credit time served for 5 days in jail and court costs. You want a year to pay the court costs?
Yes, Your Honor.
All right. Any objection from the state?
No objection from the state.
All right, so we'll give you a year to pay court costs. Thank you, sir. All right. Donnell Antoine? Pardon?
Yes, sir.
Sir, your name and date of birth, please.
Antoine, 01/15/2003.
All right, Mr. Antoine, I'm going to appoint Ms. Cunningham, that's the person sitting next to you, and her office to represent you on this matter. You're here on 2 counts. The first one is aggravated assault with a firearm, domestic violence. The second one is battery, committing domestic battery by strangulation. I have reviewed the arrest affidavit. I do find that there is probable cause for those charges. I am going to speak to this young lady here. Hi, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, so we just want to hear about the conditions of release. I've already found probable cause, okay?
Okay.
So you can put your hand down. All right, how do you know the defendant?
Father of my child?
Okay, and you are the victim in this case?
Yes.
Okay. Do you wish to have contact with him?
Yes.
Okay. Are you scared of him in any way?
No.
You want him to return to your home?
Yes.
If something like this were to happen again, would you hesitate in calling police?
No.
Has anything like this happened before?
No.
Okay. State?
No further questions from the state.
Defense?
None from the defense, Your Honor.
Okay. All right, I'm gonna, how old is your child?
1.
1?
Mm-hmm.
All right, do y'all like work together to,
Take care of her, yes.
what's her name?
Amora?
That's a pretty name.
Thank you.
You picked it.
Yeah.
Yeah, I figured. Okay, so I'm gonna, set your bond on count 1. What are the dates of these prior battery and battery on a public employee?
I'll check for you right now, Your Honor.
Thank you.
I gotta check the whole web because he doesn't have any extra cases here in Orange County, so I have to see in different counties.
What's your date of birth, sir?
01/15/2003.
You know, that's Martin Luther King's birthday. I got that it was a 2015, 2 in 2015. That's what I'm showing as a juvenile. All right.
Let's see one goes back to 2008.
You have a 2008?
2009? I don't see 2009.
I said 2015. I have 2 in 2015. In 2008, he would have been 5 years old, so I don't think it was him. Hope not. All right. So I'm going to give you a bond. I'm going to give you a bond on count 1. I'm going to give you a bond of $15,000, and on count 2, I'm going to give you a bond of $7,500. I'm going to order you to have no hostile contact with the victim. I'm going to order you to have no weapons of any kind. No guns, no knives, no ammunition. And that'll be it. Thank you.
Your Honor.
Ma'am?
We'd ask for a lower bond on count 1. They do have a 1-year-old that they share in common that he helps take care of. He's not able to afford a $15,000 bond.
Do you work?
Yes, I do.
Do you rely on him to help with the expenses of the home?
I'm sorry, can you repeat that?
Do you rely on him to help with the expenses from your home, for your home?
Yes, sir.
State?
State has no objection to whatever the court deems appropriate.
The allegations are troubling.
I understand, Your Honor, but he is entitled to a bond in which he would be able to reasonably afford based off of the charge that's being charged. I do believe that this is higher than the schedule, so we would ask for a lower bond. I understand, Your Honor. We're just requesting.
I mean, there's various instances in the one encounter that would normally You're not scared?
No.
I'll reduce count 1. Based on the history, I'm going to reduce count 1 to 2,500, count 2 to 1,000.
Thank you, Your Honor.
Same conditions.
Yes, Your Honor. Here, take this. Mhm.
All right. Name and date of birth, sir?
Matthew Bryant, 25.
Mr. Bryant, I'm going to appoint, oh, sorry, your age, date of birth, sorry.
Age is 25, I'm not in 2096.
All right. I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You're here on one account of aggravated battery on a pregnant person.
Your Honor, I did not name this as one of the ones that I had probable cause for, but I do have a PC challenge for this. May I be heard?
Yes.
Your Honor, we would argue that there's no probable cause for the charge that has been charged, specifically based off of the victim's statement stating that she could be pregnant but wasn't sure. So although the defendant in the affidavit said that she was pregnant, she is saying that she doesn't even know if she's pregnant. And that's something that the state would have to prove. So within the 4 corners of the document, we would state that there's no probable cause as charged.
State?
One moment for the state to review it.
Is this the one where he said he was trying to stop her from doing drugs because she was pregnant?
Yes, Your Honor.
Alethea Rivers for the state of Florida. In the affidavit that was written by the police officers, it does state that they had took a pregnancy test 2 days ago and that it showed that she was pregnant. So the state would say that there is probable cause that the victim in this case was present at the time of this incident.
I think based on the four corners, his own admission in there that she was pregnant, I'm gonna find probable cause for it. I'm gonna set his bond at 5,000, order no contact with the victim, no weapons, and that'll be it. Thank you.
Hold on. Yeah. Your Honor, can we get a one-time return with law enforcement?
Yes.
I can ask.
Yeah, so maintain separate residences.
Your Honor, Mr. Bryant would like to ask if the court would be willing to lower that bond. He's unable to afford it.
I just did 14 months in here fighting a case, and I just got back out, and I'm losing everything again by coming in here from an argument. I'm losing everything.
State?
State has no objection to a reasonable bond being set in the matter.
He has quite a history.
Yes, Your Honor, I understand.
2,500.
Thank you.
Terrell Jackson? Yes, sir. All right, name and date of birth, please.
Terrell Jackson, 03/17/1996.
All right, Mr. Jackson, appoint Ms. Cunningham in her office to represent you.
Your Honor, may I be heard?
Yeah.
We would argue probable cause on the charge of carrying concealed. There's nothing in the affidavit that states that the firearm was ever concealed. The officer actually states that, one of the officers actually state that they saw no, I'm sorry, I'm getting them mixed up. The officer states that he saw client had an object in his hand. He handed it to a female, and also stated that they were able to observe the gun in the open purse, which the client was not holding at the time. So all of that states that although there was a firearm, it wasn't concealed. So we would argue there's no probable cause for the carrying a concealed firearm.
State?
Alethea Rivers for the state of Florida. The state will argue that there is PC based off the officer's initial observations of a defendant, him moving in a direction and concealing himself. Also, a witness on the scene stated that she knows the defendant, that he does carry a firearm, and during the argument, he did have the firearm on his person and made a threat to use that firearm at the time. The defendant does not have a concealed firearm permit, and he is not allowed to carry one concealed. If the court does not see that probable cause has been found, the state would ask for a 24-hour reset.
And Your Honor, we're not arguing count one. I believe that there is PC within the four corners of the document. We're simply arguing that there's nothing stating that it was concealed. It's actually clear that it was not concealed.
So I'm going to give a 24-hour reset. I'll find PC on count one. I'll set bond at 10,000 on count one. No weapons. No. Oh. Apologize. Hi, ma'am.
Hi,
What's your name?
Shayna Odom.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm testimony you're about to give in this matter to be the truth, the whole truth, nothing but the truth, so help you God?
Yes,
All right, ma'am. You are listed as the victim here. Let me ask you a couple questions. Do you wish to have contact with the defendant?
yes,
Are you scared of him?
no,
Do y'all live together?
yes,
You want him to return home?
yes,
Okay. If something like this were to happen again, would you call law enforcement?
yes,
You didn't call law enforcement this time, though.
because it wasn't nothing.
Okay. All right, state, any questions?
Yes, Your Honor. Has the defendant ever been violent towards you in the past?
Sorry?
Has he ever been violent towards you in the past?
No,
Has he ever become aggressive with you?
no.
At the time of the incident, you informed law enforcement that you were in fear of your life,
I
correct?
did not even talk to them about any of that.
Have there been any prior instances of domestic violence between the two of you?
Once, I think a while back.
How long ago was that?
I don't know. I think like maybe 2 years. I don't know. Not sure.
And what happened in that incident?
Nothing, because it don't be anything but verbally.
No further questions for the state.
Cunningham?
None from the defense, Your Honor.
So I'll allow no hostile return home is okay. And the other conditions will stay the same. No weapons. All right. And then we'll reset on count two till tomorrow.
And Your Honor, what is the stated bond for count two? I
The
believe that
stated bond is no bond.
no bond. Do you want a bond or do you want me to argue tomorrow? Because your bond is going to be held high. It's probably the same. Come back tomorrow and we'll get your bond.
All right. Jarvis McCallum?
Yes, sir. How you doing?
Good. How are you?
I'm all right, but not too good in this situation.
I understand.
Yes, sir.
What's your date of birth, sir?
11/03/1988.
That's St. Martin de Porres Day. My middle name is Martin because of.
Oh, how you doing? All right, Mark.
Yeah. Well, sir, I'm going to appoint that young lady standing next to you, Ms. Cunningham, and her office to represent you on this case. You're here on one count of aggravated battery. I have reviewed your affidavit, your arrest affidavit. I do find that there is probable cause for that charge. I'm going to set your bond at $2,500. I'm going to order you to have no contact with the victim. to not return. Do y'all live together?
We was, but I got my.
All right, so I'm gonna do maintain separate residence, which
Yes.
means you can't go back. You can't have contact. No weapons of any kind, okay?
Yes, sir.
Your Honor, can we have a one-time return with law enforcement?
Sure. I'm not sure they live together, though. I think he's saying he has a set.
I got, she stay at 5214 via Hacienda Circle.
Do you-
I stay at 1117 Golden Gate Avenue.
Do you have things at her house?
She can have that.
Okay.
I don't know how to go back.
So I'm gonna,
Your Honor, we'd like it to stay so he has the option. He does have belongings there.
Yes, but I don't, she can have those belongings, sir. I don't have to go back to her house. I'm straight. I'm okay.
I'll give him a one-time return.
Just want to avoid this whole situation.
Okay. You're good to go.
Thank you. Y'all have a good day.
You too. All right, Haley Mondin. All right, name and date of birth, ma'am.
Haley Mondin, October 12, 2000.
All right, Ms. Mondin, I'm going to appoint Ms. Cunningham in her office to represent you on this matter. You're here on one count of robbery. Reviewed the affidavit, find there is probable cause, set your bond at $5,000. In order you have no contact with the victim, not return to the scene, possess no weapons, and no contact with any witnesses or co-defendants.
No.
Okay? Thank you. Patrick Sidome? Sir, your name and date of birth, please.
Patrick Sidholm, 12-3-85.
All right, Mr. Sidome, I'm going to appoint Ms. Cunningham in her office to represent you on this matter. You're here on 2 counts. Possession of methamphetamine in violation of domestic injunction. Reviewed the arrest affidavit. Does he qualify for PTR on both counts or just one?
He qualifies on both counts.
All right. I'm going to order you be released direct PTR. I'm going to order you to have no contact with the victim. That means, oh, I'm sorry.
What's PTR?
I am sorry.
That's okay.
Hi.
Hi.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, nothing but the truth, so help you God?
Yeah.
All right. What's your name, ma'am?
Marianne Koziam.
Get closer to see that mic is over on, yeah.
Marianne Koziam.
All right. And you are the victim?
Correct.
All right. So let me ask you a couple of questions. You have an injunction in place, so I assume you want to remain no contact?
Correct.
Okay. And that kind of is the only question I have.
No further questions from the state.
No further questions, Your Honor.
Okay. So there's already an injunction in place. So there's no contact allowed. I'm going to add an additional no contact. So if that injunction goes away, in this case it's still open, there'll still be a no contact in place. You understand what that means?
What?
You understand what no contact means?
Yes, sir.
All right. Means you can't call, text, email,
I
go to the
did.
house, send a message.
I didn't.
No, I'm saying, if you didn't do it, then great, but you can't do it.
Your Honor?
Yeah.
Your Honor?
Yeah, hey.
Can I speak?
Sure.
He's driving by my daughter's school, and he's not allowed per Judge Heather. She's asked him to complete several things that he has not completed.
You're talking about Judge Rodriguez?
Yes.
Yeah.
And he's driving by my daughter's school. Her teacher has put in a statement that they saw him driving in the back of the school.
So I read this one.
Okay.
To a smoke shop, sir.
I do injunctions. One of the things I do. I do a lot of things.
Sure.
This is one of them.
Hey, I have emails like.
No. So today's not the day to prove that.
Okay.
But let's address that so there's no confusion. Let me ask you a question, ma'am.
Sure.
What's your name again? I'm sorry.
Marianne.
Last name.
Koziam.
Posium.
Koziam.
Hosean.
Koziam.
All right, whatever.
Koziam.
All right, ma'am. I'm just calling you ma'am.
Sure.
Okay. Does the injunction specifically list your daughter's school?
Yes.
Okay. So the injunction, if it lists a specific place, it says you can't come within 500 feet of it. If you're going to a smoke shop or a parking lot that's within 500 feet of the school, you're violating the injunction. You can face the criminal charge. You can also face a violation of the contempt proceeding in that civil injunction case. which could result in a judge on their own without a jury, so it's not a good position to be in, can sentence you to 179 days in jail without the benefit of having a jury, just for violating the order in contempt. So you can have you can't have a dual penalty, but you can have two things going on at once. So let's be clear here. We want everybody to feel good, right? We don't want you to get in trouble, and we want you to feel safe, right?
Of course.
Right?
Right.
All right.
I don't.
So don't come within 500 feet of the school.
I'm in a new relationship. I don't even want to.
I don't care. I'm happy for you. I just don't want you to come within 500 feet of the school.
That's fine, sir.
Okay. There's a lot of smoke shops.
Yeah, you're right. You're right.
I don't know how they all stay in business. I guess you go to them, I guess. But don't go to that school.
Yes, sir.
And I'm,
Yes, sir.
we're joking, but I'm being serious.
No, you're right. You're right.
Okay. Okay. Anything else?
Is he gonna be out on bond?
So, yes, if he
I don't feel
pays the
safe.
bond.
Yeah, but we're not.
I've contacted the authorities several times, and we have an reopened case on the injunction. He's on drugs. I don't feel safe. He comes to my house at any time. He goes to my daughter's school at any time. I don't know what else to do. I've contacted the authorities several times.
I can't give you legal advice. Have you filed anything in the injunction case?
We have an injunction for 7 years, and I just went to the courthouse on Monday. They reopened it because he was in contempt because he decided to come to my house.
Has the contempt been adjudicated?
I'm not sure what that means.
Use a big word. Has the judge ordered that he did violate?
Not yet. This was just filed on Monday.
Okay. When's your hearing set?
Hasn't been set yet.
Are you sure?
I believe so, yeah.
Give me 1 second.
Sure.
Alethea Rivers for the state of Florida. The state would just like to put on the record that the defendant does have 2 pending non-arrest cases with the state attorney's office, both for a violation of domestic violence injunction regarding the victim in this case.
You guys are still married.
Correct, unfortunately. There's a pending divorce.
I know, I see it. I'm going to increase his bond on count 2 to 5,000. All right. Thank you, guys.
I'm sorry, Your Honor, what was count 1?
5,000.
Count 1.
Oh,
Your Honor?
1,000.
1,000?
I understand you want me to hold him no bond. He's legally entitled to a bond.
There's a warrant out for his arrest. I'm not sure if you see the records. He is in contempt. The judge has ordered him to do several things that he did not do. He is in contempt. There is a warrant out for his arrest, per my attorney. She has asked him to do several things.
Out for, you have a warrant for this guy?
It doesn't state a warrant. Let me double check.
Yeah. I'm looking at the court record right now. There's no warrant.
Right, because Monday the judge's assistant was contacted because he was supposed to complete several things Judge Pinder had asked him to do, and he did not. So the judge's assistant is looking into it. He was supposed to go to court on 3/27, and he did not show up. So therefore, he is in contempt for not completing 3 items the judge had asked him to do the day of the injunction.
I understand what you're saying. I don't want to get technical. Somebody may do contemptuous behavior, but until a court adjudicates it as contempt, they're not in contempt. So I understand what you're saying, that we've had non-compliance on like the batter's intervention and the other items. I understand what you're saying completely. But the domestic violence judge, Pinto Rodriguez,
Right.
needs to adjudicate that separately. There is no warrant for his arrest. And so he's entitled to a bond. Just look at me. I know you're frustrated. I understand you're frustrated. I don't expect you to be happy, okay? We just have to follow the rules and follow those procedures. No contact. I mean, you're gonna find yourself in a world of trouble. Okay? So I would just let that process play out. I'm sorry. Okay?
We have a daughter together. We don't feel safe. How much more can I express this? He's on methamphetamine and heroin. He loses his mind. I don't know what the court needs to express it more. He comes to my house unannounced at times. People on drugs should not be out on the streets, especially around children and driving to their schools. The school was on lockdown because they are aware of the injunction. When they saw his car, they locked the whole school down because of what happened in Texas. They were afraid because people like that can go crazy at any time. This is a daycare with several students there, several children there, driving back and forth several times. You read the statement. It wasn't just one time for the smoke shop. Her teacher wrote the statement. He is a danger to all of us. He needs to be in jail. Period.
He is in jail.
For a long time.
I understand, but it's innocent until proven guilty. And so we've given him a bond. The law requires me to. The state attorney, you all be in contact?
Yes, Your Honor,
with
that's
her,
correct.
a
Our
victim advocate or
advocates will
somebody?
reach out to you, and the state attorney on the case will get in touch with you as well.
And please just continue staying on top of the injunction case. And I'll tell you, there is no warrant. I know you, there is none. So,
Okay.
okay. All right.
Can you make his bond higher?
Sir.
Stay.
I think he's still reviewing something. Are we done? Oh, okay. He's still reviewing something.
As previously stated, Your Honor, the state does have 2 pending non-arrest cases involving the same victim and defendant. One is for a charge of violation of domestic violence injunction, and the other is for battery domestic violence, also involving the same victim in the case.
What are the dates of those?
For the non-arrest case for violation of domestic violence injunction, the date for that is February 28th of 2022. And for the battery domestic violence non-arrest case, it was January 16th of 2022.
Your Honor, the defense would ask the bonds to stay as they are. They took it back there. The defense would ask the court to leave the bonds as they are. Mr. Stidham does meet the requirements for pretrial release, but he is being given a bond. I do understand there are 2 pending non-arrest cases. Your Honor, emphasis on pending. The incident dates were in January and February. We're going into June, and they're still pending. So, Your Honor, we would ask for the the bonds to remain at the same. If the court if the court were to be so inclined, we would have no objection to adding pretrial release. So there are additional conditions, but we would ask the bonds to stay as they are.
Your Honor.
One of the statutory factors is safety to the community when setting bond. I mean, this, I'm going to increase the bond to $25,000 on count 2. I'm going to keep it at $1,000 on count 1. All the other conditions will remain the same.
Your Honor, I would just like to add to what she said, because she said it was a pending charge. The reason why it's pending is because I reopened the case. Because he violated the injunction. That's why so it was closed at one point, and then on Monday it reopened to pending. Because she said it was pending and it's been a while. That's the reason why. Okay.
So I'll increase on count 2 to 25. Count 1 will stay 1,000.
Thank you.
No PTR because of the legal restraints he has once.
Right, he doesn't qualify.
Right.
Sorry, what's PTR?
Don't worry, it doesn't apply.
Okay. Thank you.
I didn't mean to be dismissive. It doesn't apply. Thank you for coming.
Thank you. I appreciate it.
All right. Ian Wright. All right, your name and date of birth, please. Name and date of birth, please.
Ian Wright, 10/15/79.
Mr. Wright, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You are here, excuse me, on 2 counts, aggravated, excuse me, aggravated battery on a person over 65 years of age with great bodily harm and aggravated battery of domestic violence. Reviewed the affidavit, find there's probable cause.
Your Honor, may I be heard on probable cause?
Oh, I'm sorry. Yes.
Your Honor, the defense takes the position that, number one, this is one incident, so there's no probable cause for both charges. Additionally, there's no probable cause that there was great bodily harm. I did take the opportunity to look up the statutory definition of great bodily harm. It states it's great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I believe that it was stated that there was a mark on her neck and her throat was sore. The defense takes the position that does not amount to great bodily harm.
Alethea Rivers for the state of Florida. The state would contend that that does involve great bodily harm. The defendant placing his hands around the victim's neck, closing off her airways, restricting her breathing so that she is not able to breathe does cause great bodily harm. There was serious injury due to the officers being able to observe a redness on the victim's neck. That shows that the defendant did apply so much pressure to her. Usually in strangulation cases, bruises aren't visible. So the fact that there was injuries to the victim's neck does show that. Also, there was a large bruise and swollen area on the back of the victim's head from her head striking the ground in this case as well. Also showing that there was serious bodily harm that was caused to the victim.
May I interject for 1 second to
Yes.
both of you, for both of you? In terms of the great bodily harm, I'm looking at the statute. Are you challenging on count 1 or count 2 first of all?
Well, I was challenging that there wasn't PC for both charges, only one.
Just on the great bodily, so on both on great bodily harm?
Yes, Your Honor, and additionally, I'm sorry, I didn't mean to.
No, so my question then, on count 1 only. I'm reading the statute, it seems like it's an or. So it doesn't seem like it's an and, it seems like great bodily harm or if the person's over 65. Whenever a person is charged with committing or assault or aggravated assault or a battery or aggravated battery upon a person 65 years of age or older, regardless of whether they know the age, the case shall be reclassified as, then it goes on. So isn't it an or am I mistaken on that?
Your Honor, I do believe it's an or. I'm still making the argument on great bodily harm in general because it is attached to, it is an or, so if you believe that there's aggravated assault on a.
Well, I think on count 2, your
Yes, Your
argument
Honor.
is with merit, but I'm talking about just count 1 right now.
Just for count 2, Your Honor.
Okay.
And additionally, I would like to point out that they were both named as victims in this case. The officers did find that the victim in this case contributed to the fact that her head hit the ground. I know that the state pointed out the bruises that were on her head, so I'd like the court to take that into account as well. And I do believe the victim is present.
All right, ma'am, can you raise your right hand for me, please? Solemnly swear a firm testimony you're about to give in this matter. Or in this case, to be the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, what's your name, ma'am?
My name is Autumn Ficken.
All right, and you are the victim?
Yes,
All right, and what's your relationship to the defendant?
he is my nephew.
All right. Let me ask you, do you want to have contact with him?
No,
All right, you don't want him to return home?
I am presently supplying daily medical attention for my sister, who owns that home, and he lives there. I need to enter.
Your Honor,
Yes, ma'am.
they do not live in the same home. He lives with his mother. As the victim just stated, she is the caregiver, but she does, from my understanding, she does not live there.
Dawn Swanson is the mother?
Dawn Swanson owns the home. She is the mother. She is my sister. And again, I'm providing daily medical care.
What hours do you go to the home?
I would need to go to the home. It's a 24-hour basis. Basically, I would get there maybe 5:15 in the evening. I also provide a few personal services while I attend to the medical situation. So I would be there for about an hour.
For an hour?
Mhm.
And 1 hour each day?
As long as there are, at a minimum, yes. If I need to stop for groceries, then I would have to put those away. I would anticipate an hour basically would cover it.
Okay. How big is the home?
It is a 2-bedroom home, a living room and a small dining room kitchen. These are small rooms. It is a small home.
Do you live there?
Yes. And I am mother's caregiver since 2017.
You're the caregiver?
Yes. When my mother was admitted to the hospital for liver failure in 2017, she filled out a sheet of paper that says 3 caregivers. Myself, Kathy Wright, Judy Bradshaw. It is signed and notarized.
Since then, she has signed
Don't
me.
interrupt. I'm going to come back to you. Don't interrupt.
I live there. I take care of her. I pay the bills. I pay rent. I do the cleaning.
One second. It seems fairly apparent that it's his home. It's a home
No,
he
it is
lives
not
in.
his home. It is my
It's the
sister's
home he lives in.
He pays rent and lives on the couch.
Hold on, guys, don't interrupt each other, please. I have a little bit of difficulty. I understand where you're coming from, but I'd have a little difficulty kicking him out of a home that you don't live in.
I'm not particularly asking for him to be kicked out. However, I dispute that he provides the services that he just listed, because when my sister came home from the hospital and was not ambulatory, he left her in the dark for 2 days without responding to her needs.
That's not true.
So let's go back to the PC argument and we'll deal with that in a second. So on the PC argument, Ms. Rivers, I'm having a little bit of difficulty finding that it's not one event.
I'm sorry, what do you mean, Your Honor?
Yeah.
Can you say that again?
I'm having a little difficulty finding that it wouldn't be one event. It's 2 charges, almost identical, but stemming from the same event, isn't it?
He has put his
Ma'am,
hands.
Ma'am, just please. We have to go based only on what's written. We can't consider your testimony for this.
I would agree, Your Honor, that they are the same act or occurrence, so.
Yeah, so.
If we could.
I'm gonna find no PC on count 2. On count 1, I'm gonna find PC, because of the age, not because of the actions. I'm gonna, he doesn't qualify for PTR?
No, no, Your Honor, due to the charge.
I'm gonna set bond at 2,500. I'm gonna order no contact with the victim. That means you can't call, you can't text, you can't email. I'm gonna order you all to maintain separate residences. That means you guys can't live in the same house. Okay? In terms of, does anybody else live at that home besides your mother?
Just me and my mom.
Okay. I think we just need to have no contact until it can be sorted out later on. Today's probably not the correct venue for that. So I'm gonna do no contact. Yes.
My only concern is that the no contact order, it does state you must not be within 500 feet of the victim. And so since she comes to the home, I'm not sure how that's gonna work, and I don't want him to be in violation of the no contact order.
Right. So generally, what's that?
I'm the caregiver. I have taken care of everything.
Yeah, well, it's your house. I mean,
I've taken care of everything in that house since 2017 with no problems.
I can't enjoin her from going there. That's the problem. Like, she's not a party to the, well, she's a party to the case, but she's not, I don't have jurisdiction to say, hey, you can't go there to her.
And I'm not asking for that, Your Honor.
I understand if you want some clarifying language on the order, is that what you're asking?
Yes, please, Your
What do
Honor.
you propose?
Your Honor, I just,
Do you work, sir?
Yes, I do.
Advent Health.
Advent Health and Facilities and Mapping Departments. My hours are usually 8 to whenever I finish that day, which can be anywhere from 4:30 to 6 o'clock.
What days of the week do you work?
Monday through Friday. Fridays are usually early days because I run out of hours.
Is that regularly?
Yes.
Okay. Is it possible for you to go to the home while he's at work?
The earliest that I can get to her home is approximately 15 after 5 p.m., Monday through Friday. He has not attached.
And I understand where you're coming from. I just can't make somebody leave their home.
Doesn't need to be there.
But I can't say she can't come.
My mother is at the house. I live at the house. My mother has no problems against texting me if she needs something. That Publix, where her pharmacy is 1.4 miles from the house.
like,
It
Your
is
Honor.
on my way.
Your Honor, I believe that clarifying instructions on the order, just stating that when she does present herself to the home, he's not in violation of the 500 feet rule.
Yeah, that's fine at a minimum. I just want to be clear here. I don't want him to get arrested for just being at his house.
Yes, Your Honor.
And so, State, do you have any thought on this?
The state can only suggest that maybe putting in the order that the defendant can have possession at the home located at 5050 Old Cheney Highway, Orange County, Florida, and that is his residence.
Your Honor,
I mean, all that's true, so can I see the note?
Your Honor, can we explain no hostile contact to the victim and see if she would be okay with it? I know she says she doesn't want contact, but based off the situation, I just want to make sure she understands no hostile and see if she would.
So no hostile means he can't yell, scream, shout, hit, say anything aggressive or make any aggressive movements towards you.
Hey, that would be great, except that I ended up on my back on a concrete floor because he pushed me through 3 rooms yesterday.
Wasn't 3 rooms.
Okay.
I had injuries. Okay, sir. She's trying her best right now. Okay? She's doing a good job. All right, so here's what we'll do. We're gonna keep the no contact. We'll put in a provision that clearly states, and I'm gonna say what I wanted to say. Defendant Ian Wright is not violating the no contact order by remaining in his home when the victim arrives there, period. While there, he is to have no, I'm gonna say no direct, well, does she have a key to the house? How's that work?
I don't know. There's
Yes.
There's supposed to be.
You have a key?
Yes.
So you don't have to go open the door for her or anything like that?
I shouldn't know.
Okay. So if I said the defendants have no direct contact with the victim while she is in the home, meaning you just stay in your room.
May I change the locks so that she does not? Because
I can't tell you what to do at your house. We have freedom, you know? We're not in California.
Again, it is my my sister's
It's
house.
not your house. That's what you
But
can't.
it is my
My
sister's
sister's got
house.
2 houses. I can't tell her what to do at her house.
Again, if she doesn't want the locks changed and she wants me to have access to the house, it is my sister's house.
Sure. I'm not disagreeing with you, ma'am. I'm not disagreeing with you.
And she needs a 24-hour administration of antibiotics for a serious bone infection for a long-term care.
Have osteomyelitis,
Yes.
and so she doesn't have a home health nurse.
Not for that daily situation. A home health nurse would come, it is supposed to come once a week to attend to her PICC line, but not for that daily connection. And
Why
and
is
the
it?
thing
Why
that-
does it have to be you?
because he hasn't been willing to learn how to do it.
So, you need to be there for 1 hour.
Yes.
Okay. So I just want to avoid a situation where she stays for like 5 hours and then he's like locked in his room
Yes, Your Honor.
for it. So, State, you got anything for me?
If Your Honor would like to put in for the victim to be able to return for 1 hour between the hours of 5:15 and 6:15, Monday through Friday, and during that time, the defendant isn't to be home.
Your Honor,
I'd rather we just stay, because this is like.
I think the language as stated is going to be okay. He's not in violation by remaining in home while the victim arrives. No direct contact with victim while in the home. I don't want to put any constraints on the times that she can come in because there might be traffic, something might happen. Her mother does need that care. I do think the language as it states should protect him.
It also is a seven-day treatment. I mean, it's 7 days a week.
I know. I'm familiar with it. I'm familiar with she's on an IV line.
Yes.
Or PICC line. It's
Yes.
not an IV line, it's a PICC line.
Yes.
Okay. So we're just gonna go with the language. Thank you, ma'am. Probably gonna have a hearing, seeing who's assigned to this case. Have a hearing with somebody. Judge Barbara. Okay. She can have fun with it. All right. Thank you, guys. ROR. Well, I found no piece. This is really what it is. So 2,500 in count 1, no contact, no weapons. And then count 2 is no piece. All right, thank you, sir. Thank you, ma'am.
Thank you.
What's your name?
Jakesia Bibbs,
Perfect. All right, what's your date of birth, ma'am?
April 28th, 2000.
All right, Ms. Bibbs, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You're here on one count of battery. I've reviewed the affidavit. I find that there is probable cause for that charge. I'm going to order you be released direct PTR, but order you to have no contact with the victim.
Your Honor, if I may. I believe the victim got in contact with pretrial release, stating that they were trying to attend but couldn't find their car keys, and also that they wanted contact and want her to return to the residence. They also confirmed that she was a stay-at-home mom, and I'm getting this from the pretrial release paperwork, so I would like ask for that to be verified.
Correct, that's correct.
All right, so I'll order no hostile contact then. No weapons of any kind. That'll be it.
Here we go.
All right. All right, what's your name, ma'am?
Nerilisa Escobar.
All right, Ms. Escobar, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You're here on one count of battery domestic violence. Domestic violence has to have a monetary component. It can't just be straight PTR, right? Per statute.
Yeah, they'll be monitored. They will have to come to the office.
All right, I'm going to appoint Ms. Cunningham and her office to represent you. I'm reviewed your charge of battery of domestic violence. I reviewed the arrest affidavit. I find there is probable cause for that charge. I have no history, so I'm going to order you be released on $50 with PTR. I'm going to order you have no contact with the victim to maintain a separate residence. No weapons of any kind.
No.
Thank you, ma'am. All right, name and date of birth, sir.
You said what?
Your name and your date of birth.
Jamel Jenkins, 10/13/03.
All right, Mr. Jenkins, I'm going to appoint Ms. Cunningham and her office to represent you in this case. You are here on one count of battery domestic violence. Reviewed the arrest affidavit to find that there is probable cause for that charge. I'm going to order you to have no contact with the victim, not have any weapons of any kind. I'm going to order you be released on $50 bond with PTR. And that's it. Thank you. Maintain separate residence. All right, name and date of birth, please.
Jeffrey Sean Lemieux, 1985, December 8th.
All right, Mr. Lemieux, you are here on, I'm going to appoint Ms. Cunningham and her office to represent you. You're here on one count of one count of battery, touching or striking. I've reviewed the affidavit to find there is probable cause for that charge. Based on the history, I'm going to order you to be released on $50 with PTR. I'm going to order you to have no contact.
May I ask what the PTR represents, what that means, sir?
It's an office that you check in with, make sure it's like a probation, but before you, pre-trial, probation. It's basically, I mean, is that a fair description?
Yes.
Yes.
Your Honor, we'd ask for a one-time return so he can grab some belongings.
Yes, yes. And I'm also going to order you to have no alcohol. So no alcohol, drugs, or other controlled substance, and no weapons.
Of course.
Okay. All right. Thank you.
Hello.
Sir, your name and your date of birth, please. Your name and your date of birth, please.
Desmond Lindsay, April 7, 1997.
Okay, Mr. Lindsay, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. Here on one count of battery, dating violence, reviewed the affidavit. I do find that there is probable cause for that charge. He does not qualify for,
No, Your Honor.
what's the reason?
Either no emergency contacts were provided, unable to verify community ties.
I'm gonna find probable cause. I'm gonna set your, bond at $250. Order you have no contact with the victim, maintain separate residence, no weapons of any kind.
Do you have any belongings at her house?
Your Honor, can we get a one-time return with law enforcement?
Yes. Okay, thank you, sir.
So you have $250. You can bond out. If you don't have contact with her, you can't work with her, but if you need to go get your stuff, just call law enforcement before. Okay? You can do a bond and pay them on the Okay?
Okay, name and date of birth, please.
Jordan Perrault, June 4th, 1991.
All right, sir. I'll report appoint Ms. Cunningham and her office to represent you on this matter. I've reviewed the arrest affidavit. I find there's probable cause for a charge of battery, domestic violence. Set your bond at, $250 with PTR. Order you have no contact with the victim. To maintain a separate residence, we will allow one-time return with law enforcement. No, weapons of any kind.
No, you have to pay $250.
Thank you. Name and date of birth, sir?
Donald Anderson, 6/1985.
1 second. All right, Mr. Anderson, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You're here on one count of drug possession, controlled substance without a prescription. Reviewed the affidavit, find that there is probable cause, set your bond at $1,000. Order you to not have any drugs, alcohol, or other controlled substance without a prescription. Thank you, sir. Name and date of birth, sir?
Joshua Allen Bruner, 7591.
All right, Mr. Bruner, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You're here on 2 counts. sorry. You're here on a warrant. You're here on the capious warrant, so another judge has already found probable cause. Set your, bond on count one, dealing in stolen property at 1,500. On count two, receiving money from pawnbroker at 1,500. So your total bond monetarily is 3,000. Also have no contact directly with the victim, or co-defendants or witnesses, and not return to the scene of defense, and not possess or consume any alcohol, illegal drugs, or controlled substance without a valid prescription.
He does have, open case.
I'm sorry?
He does have an open case.
We'll revoke on the open case.
Your Honor, if I may be heard.
Sure.
We'd ask for no action to be taken on the open case. The reason being, it is a possession case, but it hasn't been filed on. The complaint was filed on February 21st, and there has been no action on the case since then. So we would ask for no action, for the bond to not be revoked in that case.
Has it not been filed on?
Does Your Honor have a case number for that?
2022 CF 001995 AO.
No, Your Honor, it has not been filed on yet.
We'll take no action on that. So your name and date of birth, please?
Kenyon DeAndre Bryant, May 2nd, 1993.
All right, Mr. Bryant, I'm going to appoint Ms. Cunningham and her office to represent you. You're here also on a warrant. So another judge has already found probable cause on count of sale of delivered cannabis. Set your bond at 2,500. And then there's a second warrant. So another judge has also found probable cause. Set your bond, at 2,500 on each count for possession of cocaine and possession of cocaine with intent to sell. So your total monetary bond in that case is $5,000. So between those two cases, it is 7,500. I will add the condition of no drugs, alcohol, or other controlled substance without a prescription. And I will revoke on 22 CF 3312.
Your Honor, if I may be heard.
Sure.
We would ask for no action to be taken on that case. The complaint was filed on March 25th, and there's been no action, has not been filed on.
Okay, it hasn't been filed on? All right, so we'll take no action.
Thank you.
So your monetary bond, 7,500. No drugs, alcohol, or other controlled substance.
Thank you, sir.
Thank you.
Okay.
Name and date of birth, sir?
Quan Butler, 07/24/1999.
All right. Mr. Butler, you're also here on a warrant. A judge has already found probable cause. I'm going to appoint Ms. Cunningham and her office to represent you. Your charges on 8 counts are count 1, aggravated battery with a motor vehicle. Count 2, aggravated battery with a motor vehicle. Count 3, same. Count 4, aggravated assault with a firearm. Same on count 5. Count 6 and 7 are aggravated child abuse. Count 8 is criminal mischief. Your bonds have been set by that judge as follows. Count 1, 10,000. Counts 2 and 3, 250 each. Count 4, 5,000. Counts 5 and 6, 7 and 8, all 250. Your total monetary bond is 16,500. Also, no contact with the victims.
Your Honor,
Yes?
I believe there's a victim.
Oh, sorry, thank you. Can you raise your right hand for me? Solemnly swear or affirm testimony you're about to give in this matter to be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
I can't hear you. Make sure you speak into that
Yes.
mic. All right. What's your name?
Autumn Taylor.
All right, and you are the victim?
Yes, I am.
All right. So, do you want to have contact?
No contact. I would honestly like to request that he does not receive a bond.
That's the only question I have. State,
No further questions from the state.
defense?
None from the defense, Your Honor.
So I'm gonna order no contact with the victim. No, weapons, firearms, or other ammunition. No return to the scene. And then on, case 22 CF 2629, I'm going to revoke your bond, so you'll have no bond.
Your Honor, we would ask for no action to be taken on the case he's out on bond for. He does have pre-trial conference coming up on the 8th. So although it has been filed on, the case is moving forward.
I'm gonna revoke his bond on that.
Yes, Your Honor.
So does that mean that he will not be released?
We'll have no bond on the other case, correct?
Okay, what about this case?
He has monetary bonds as per the warrant.
Okay, well, is there any way that that can get raised or something like that, or if there's terms and conditions? Because he's been coming to my apartment complex, he's been harassing me. I'm in constant fear for me and my children's life. Like, this is not okay. I've been out of area for the last month and a half because I've been so terrified to return home.
State, you just have to have somebody contact you from the state attorney's office to do that. I'm not gonna change a bond another judge set already. The one that has the case, I believe. So, but I'm gonna revoke on the 22 CF 2629. Okay. All right, thank you.
Your Honor, Deborah Cooks is medical.
All right, thank you. All right, sir, your name and date of birth.
Listen to the judge. Name and date of birth.
Your name and date of birth.
08/20/1997.
Your name.
Sheila Delancey.
Okay, Mr. Delance, I'm gonna appoint Ms. Cunningham in her office to represent you.
Your Honor, we waive the reading of the charges.
Another judge has already found probable cause on these charges. I'm going to set your bond at $25,000 each count. So your total monetary bond will be $75,000. And I'll just adopt the conditions that were in the warrant.
Your Honor, what were those conditions? I apologize.
No contact with the victim and no contact with anyone so similarly situated.
I'll have the warrant sent to you. You have to go up there. Take this with you.
Name and date of birth, sir?
Stephen Craig Evan, date of birth 7/23/1960.
All right, Mr. Evern, I'm going to appoint Ms. Cunningham in her office to represent you. You're here on a moving traffic violation, driving while license suspended as a habitual offender. Reviewed the affidavit, find there is probable cause. Set your bond at $5,000. Order you to not operate a motor vehicle without a valid driver's license. On case 22 CF 5654, I will revoke. Same charge. Thank you.
Speak to your attorney.
So your name and date of birth, please.
Marvin Isaiah Hill, 6/1977.
I'm going to appoint Ms. Cunningham in her office to represent you. You're here on 3 failures to appear. So another judge has already issued a warrant for your arrest for failing to appear. Set your bonds as follows. Count 1, 5,000. Counts 2 and 3, 100 each. So your total monetary bond will be 5,200.
Would I be able to say something?
This is not.
Thank you.
Aaron Lopez bonded.
Aaron Lopez. Okay. Name and date of birth, sir?
March 14th, 1983.
Your name?
Patrick Mason. Patrick Mason, Perret, Amy.
Okay. I'm going to appoint Ms. Cunningham and her office to represent you on this case. You're here on 2 counts, possession of firearm by a convicted felon.
Your Honor, I believe it's a possession of a firearm by convicted felon and possession of ammunition by
What did I say?
2 counts of possession of a firearm.
Wait, and what do you say it is?
I could be wrong. I believe it's possession of a firearm and possession of ammunition.
Oh, you're right. Okay. So I have 1 count of possession of firearm by convicted felon and 1 count of possession of firearm or ammunition by convicted felon?
Yes, Your Honor.
Okay. Those are your charges. I'm going to find PC. I'm going to set bond on count 1 at 4,000, count 2 at 150. Order you to not possess any weapons of any kind.
No, sir.
All right. Thank you.
Mm-hmm.
Gotta move. I knew we were gonna get done by 2, but we're gonna get done by 3.
How you doing?
Okay, how are you?
All right, name and date of birth, please.
Sean McClendon, February 21st, 1992.
All right, Mr. McClendon, I'm gonna appoint Ms. Cunningham and her office to represent you.
Your Honor, we waive the reading.
Alrighty. You're here on a warrant, so another judge has already found probable cause. I'm gonna order you be held no bond. And let's see what conditions. Not possess any weapons or firearms and no contact with victim. All right, thank you.
Your Honor, Elijah Perez bonded.
All right, great.
Your Honor?
Yes.
He's expressed that he does not want the office of the public defender appointed for his case.
Okay. You have an attorney?
I represent myself, sir.
You want to represent yourself?
Yes, sir.
Okay. All right, so I won't appoint the office of public defender. No bond.
Okay.
Thank you.
Am I able to speak on my behalf now? No?
There's a
What's your last name?
Is her name and date of birth?
Brian Reynolds, 02/12/94.
Mr. Mr. Reynolds, I'm going to appoint Ms. Cunningham and her office to represent you on this case.
Your Honor,
Ma'am?
I'm not arguing probable cause, but we would ask for ROR on count 2, since the Office of the State Attorney is not filing charges on possession of cannabis cases for less than 20 grams.
So there's three co-equal branches of government. There's the executive branch, there's the legislative branch, and there's a judicial branch. And I'm sorry, this is going to be a little bit of a rant here. So, the legislative branch makes laws. The executive branch, they enforce the laws. The judicial branch says what the law is. The law is that it's against the law to do it. They cannot choose to possess it, but bond by the legislature, which makes the laws, says the judiciary is the one that sets bond. So I don't care what their office does.
Yes, Your Honor, it was just a request.
I know. It's a pet peeve, not on you, just in general. Anyway. Hi, Mr. Reynolds. All right, so I'm gonna find probable cause on the 4 counts. On count 1, I'm gonna set your bond at $1,000, the next 3, $100 each.
Yes, sir.
Order you to not possess any controlled substance without or any drugs, alcohol, or controlled substance without a prescription.
Yes, sir.
All right, thank you, sir.
Your Honor, what was the bond for count 1?
1,000 and then 100. All right, sir, name and date of birth?
Rivera Torres, 22887.
You have an appointment, Ms. Cunningham, in her office to represent you. You are here. All right. You're here on 2 cases, I believe. On case 1, you have 4 counts: trafficking in fentanyl, possession of cocaine with intent to sell, deliver, possession of methamphetamine with intent, and possession of drug paraphernalia with intent. Reviewed the affidavit, find probable cause for that. On the second case, you have 3 counts: false imprisonment, battery, and petty theft. On the first case, count 1, 100,000, count 2 and 3, 150, count 4, $100. On the second case, count 1, 3,000, count 2, 150, count 3, 100. I'm going to order you not to have any controlled substance, narcotic, or illicit drugs without a prescription. And, on the open case 22 CF 64, is it just 640? 1040, I'm sorry.
Your Honor, may I be heard?
Sure.
We'd ask for the court to take no action. This incident occurred on January 27th. He's out on a 33-day motion, and there still has not been an information filed.
All right, the court will take no action.
Tell your attorney if you're appointed and tell them.
Your Honor, Robert Roman Fuentes is in the hospital.
All right, so medical reset.
Yes, sir.
Sir, your name?
Karan Scott.
All right, Mr. Scott, I'm going to appoint Ms. Cunningham in her office to represent you.
Your Honor, may I be heard?
You may.
Your
This
Honor.
is the PC challenge, right?
Yes, Your Honor. Your Honor, it's alleged that the incident occurred with the use of a fire extinguisher. The statutory definition of a weapon is defined as an object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. For that reason, we would take the position that a fire extinguisher does not qualify for the definition of a weapon.
State.
One moment, Your Honor.
That's on count 2.
I think it also goes with count 1 because it's charged as a robbery with a weapon.
He's only here on one case, right?
Yes, Your Honor. Your Honor, may I ask what courtroom this is in? Like what judge this case is in front of?
Courtroom 1, Judge Magic.
The
Oh, you mean, yes. Do we know? Well, just look at the order. Strobridge.
I know there's attorneys in that courtroom, we'll be okay.
Anything?
They would just argue that a weapon in this context is any weapon that is used or threatened to be used in a way that is likely to produce death or great bodily harm. The fire extinguisher in this case was used in a way that would cause possibly death or great bodily harm, given that the make of a fire extinguisher and the way in which
What
the
are you reading
defendant
from? I'm sorry.
used it.
And what were you reading from? Ms.
Your Honor, I pulled the definition from the jury instructions given by the Florida Supreme Court.
What are you reading from, Ms. Rivers?
Just a website that I found that states that an object is a deadly weapon if it likely can cause death or great bodily harm.
Give me a sec. Is the charge deadly weapon or weapon?
Just weapon.
I did also pull up the jury instructions for aggravated battery. And a deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design or construction. The state would just argue that the fire extinguisher is an item or an object that would likely cause death or great bodily harm if it is used in a way that it was used by the defendant.
And Your Honor, that is the exact definition that I also pulled up. A fire extinguisher used in the ordinary and usual manner contemplated by its design and construction is not a weapon.
Also, the state would like to also add in from the jury instructions for aggravated battery, an object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. The manner in which the defendant in this case used the fire extinguisher was a way that could have caused the victim's death or great bodily harm to the victim in this case.
I'm gonna find PC. Set bonds on count 1, 10,000, count 2, 150, count 3, 150.
I'm sorry, Your Honor, I didn't hear count 2 and 3.
150, 150 bucks. Order no contact with the victim, no return to the scene, no weapons. Yep. Thank you, guys.
Excuse me? No weapons. No weapons, no return to contact. So you can't have any weapons.
So your name and date of birth?
John Edward Smith Jr., 11077.
I'm going to appoint Ms. Cunningham and her office to represent you.
Your Honor, may I be heard on PC for count 1?
This wasn't one on my list.
That was my fault, because it was on my list from the beginning.
Sure.
Your Honor, the defense states that there's no probable cause for possession of methamphetamine with intent. There's nothing in the affidavit about weight or amount. There's just a small case, we don't know how big that case is, that had a bag with what appeared to be meth and also a bag of what did presumptive positive for fentanyl and an unidentified white powder. For those reasons, we'd state that these facts don't arise to possession of methamphetamine with the intent to distribute.
Mr. Rivers?
One moment, Your Honor.
And Your Honor, I think this is my last PC challenge for the day.
Alethea Rivers for the state of Florida. To prove the crime of possession of methamphetamine with intent, the state must prove the following three elements. That the defendant sold, manufactured, delivered, or purchased, in this case, possessed with intent to deliver a certain substance. The police report does indicate that the officers field tested the objects found within the small black case. They did field test presumptive for meth and fentanyl. The substance was the specified substance as stated. Again, the officers tested those substances, and the defendant had knowledge of the presence of those substances. These substances came off the defendant at the time that this happened, and they were in his possession at the time of the incident.
And Your Honor, the defense would concede that the substance did test presumptive positive for methamphetamine.
We're talking about the intent to sell.
Correct. Where I'm not challenging, it is possession of methamphetamine with intent to sell, so I'm not challenging the possession of methamphetamine, specifically the intent to sell.
The elements listed here don't require the state to show the amount of the possession or the amount of the substance as listed. The only requirement is that the defendant possessed with intent to sell, manufacture, distribute the substance, that the substance was the alleged substance, and that the defendant had knowledge of the presence of the substance.
I don't find PC for intent to sell. I find PC for just possession of the methamphetamine. So I'll find no PC for the possession, but I'll find PC for possession. So we'll change.
You're gonna get a bond.
So PC for possession at 2,500, and then possession of fentanyl.
I'm sorry, Your Honor, I can't hear you.
Oh, sorry. The possession, just straight possession, 2,500 bond, and then count two we'll keep at 150.
Thank you, Your Honor.
And no, no possession of any controlled substance without a prescription as a condition. Just straight possession, not the possession of intent. Does that make sense? All right. Name and date of birth.
Mario Damon Snell, July 23rd, 1974.
All right, Mr. Snell. I'm going to appoint Ms. Cunningham in her office to represent you on this case. You're here on one count of sale delivery of methamphetamine. Another judge has already found probable cause and, excuse me, set your bond at 7,500. So I will stay that bond. I'll also say no condition, or as an additional condition, no possession of any controlled substance without a prescription.
You mind if you can lower that a little?
No.
Talk to you.
What was that? And then I'm gonna revoke on 21 CF 12728.
That was for Snell?
Yeah.
Well, we had to take that one back because
Oh, yeah.
the way it's weird
Okay,
is
so I'll
like,
take no.
oh, okay.
No action. So he's not out on bond?
No, because the warrant that he came in on happened before the charge that he
Oh.
bonded out on.
Gotcha. Okay.
Ronald Solomon Muhammad, bonded.
Name and date of birth, please.
Gage Strobridge, 7493.
All right. I'm going to appoint Ms. Cunningham in her office to represent you. You're here on a petty theft, 2 prior convictions. Another judge that already found probable cause. Set your bond at $1,000. I will stay that bond. I'll order you to not return to the scene. All right, thank you. All right. Name and date of birth?
Robert Swilly, 9469.
All right, I'm gonna appoint Ms. Cunningham in her office to represent you. You're here on 2 counts, grand theft and conspiracy to commit grand theft. Reviewed the affidavit, find probable cause. Set your bond at $1,000 each. Order you to have no contact with the victims. Thank you. Sir, your name and date of birth, please.
Alfredo Torres, sir.
And your date of birth?
Your date of birth?
3/12/82, sir.
I have an appointment, Ms. Cunningham in her office to represent you.
Your Honor, may I have a moment?
Sure.
Please.
Thank you, Your Honor.
You're here on 2 counts, possession of firearm by convicted felon, possession.
Your Honor, I believe it's a possession of a firearm and possession of ammunition.
Right. So one is possession of firearm, the second one is possession of ammunition.
Yes.
Yeah, you didn't let me finish.
Oh, I'm sorry.
I'm gonna find probable cause for those charges on count 1. Set your bond at $4,000 on count 2, $5,000.
Your Honor, we'd ask if you'd be willing to lower one or both of those bonds so that he can afford it.
I'll lower the second one to $2,500.
Thank you, Your Honor.
I'm gonna order you to not possess any weapons. On 22 CF 2658, has he been charged?
Your Honor, I do not believe there has been an information, but I didn't make note of that one.
Alethea Rivers for the state of Florida. Our office has not filed charges.
All right, so I'll take no action.
Thank you, Your Honor.
Next one, thank you.
Your Honor, Vasquez Gall, Luis Antonio bonded.
For count one, 2,500 for count two. You need to put 10% down of the bondsman. 400 and 250. You gotta go talk to a bondsman.
Your name, sir?
Put your mask on.
Matthew Williams.
All right, Mr. Williams, I'm going to appoint Miss. Oh my gosh, I completely just blanked.
I've been here all day.
I know.
Cunningham.
Cunningham. And her office to represent you on this matter.
I understand. Okay, I understand. Give me just a second.
Since we're on. Hold on one second. Go off. Okay. I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You are here on one count of grand theft.
Your Honor, may I be heard?
Yes.
Your Honor, we'd ask for the court to take in consideration when considering the bond on this case. Mr. Williams is disabled. He is out on 2 other cases, and those 2 cases have been put into the competency route. So he has been adjudicated incompetent on both of those 2 cases. So we'd like the court to take that into consideration when giving a bond amount.
If he's incompetent, he's been deemed incompetent?
It appears to be so. The notes say specifically competency cases on both of the 2 that he's out on.
But have they adjudicated him incompetent?
I can double check.
And then the date of that finding, if it's been made?
Your Honor, he was adjudicated incompetent by Judge Alvaro on 5/27/2022 in case number 22 CF 000-507AO. And
I don't think I can take action, but
not on the ones that he is out on.
no, I don't think I can take action if he's incompetent.
Your Honor, being completely candid with the court, he has not technically been adjudicated incompetent in this current case before the court.
Said Judge Alvaro.
On the 2 that he's out on, yes, but he would need to be adjudicated in the case that he's here for today. So we would ask, if the court is willing to release him ROR, then we, of course, would not object to that. But if the judge wants to give him a bond, we would ask for the consideration to be taken that he is incompetency in the other cases. It is recent, and it's likely for those findings to be adopted in this case.
State?
The state would object to RRR in this case.
I'm gonna find PC. I'll set his bond at 1,000. I'll take no actions on the others. No contact with the victim.
Let your attorney know. $1,000.
Name and date of birth?
Name and date of birth.
July 15, 07, July 15, 1974.
Hold on.
All right, Mr. Wilson, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You're here on 2 cases. First case is possession of cocaine, possession of drug paraphernalia. Second case is expired driver's license. I'm going to find probable cause for all 3 charges on the 2 cases. On case 1, count 1, $1,000 bond. Count 2, $100 bond. Order you to not possess any drugs, alcohol, or other controlled substance without a prescription.
Your Honor?
Yes.
Sorry, you were talking really fast. It does look like he qualifies for straight PTR.
I'll give him $100 on count 1 with PTR, $50 on count 2 with PTR. And on the third case, I'll give him straight PTR. Or the second case, third count, straight PTR.
Any conditions, Your Honor?
Not operating a motor vehicle without a driver's license, and not possessing any drugs or controlled substance without a prescription.
Your Honor, Wilson Tamelia Lachey, bonded.
Your name and date of birth.
Billy Wright, 110491.
All right, Mr. Wright, you're here on one count of possession of a controlled substance. Another judge that already found probable cause set your bond at $2,500. I will stay that bond and order you not to have possession any drugs or controlled substance without a valid prescription.
Your Honor?
Yes.
This is yours. Can we take a 2-minute break, Your Honor?
Sure.
Thank you.
Let's go off the record. You are here on a trespass case.
They also said I had a warrant for a
Well, hold on. So what it looks like is you failed to appear for a plea hearing this week.
Yeah.
And so the judge issued a KPS for your arrest, that's a warrant,
Yes, sir.
and set your bond at $2,000.
$2,000, yes.
Your Honor?
Yes.
Can I ask the state what that offer was?
It was time service.
Stop.
The state has no offer on this case. I don't know what it was for his previous case that he failed to appear on, but at this time, for this case, the state has no offer.
Your Honor, may I have a moment to check?
Sure.
Do you have a public defender for this case?
Time served. I should show that.
Your Honor?
Yes.
This case is currently in front of Judge McGinnis in Division 81. It does look like he was set to take a plea of an adjudication of guilt, credit for time served, court costs, and the cost of prosecution. Would the court be willing to take that offer at this time?
No, not at this time. Failed to appear. I don't know what they're gonna do.
So I'll tell your attorney that you're here.
Because I have that he has a felony case.
Yeah, they didn't charge me.
Your Honor, the warrant is for the trespass, misdemeanor trespass.
They haven't charged me with it.
Sir.
State, do you have a position on the just trespass aspect?
Can you say that again, Your Honor?
Sorry, do you have a position on it, the trespass?
The state has no offer at this time, and the state would ask that the bond just be kept as is on the trespass, and if the defendant does want to take the plea offer that was offered in Judge McGinnis's courtroom, that he be able to go back and take the plea there.
Your Honor, we would plead to the court to accept this offer for the simple fact that the state was willing to give him credit for time served. He was set to take that plea. It's already been relayed to him. And so to not accept the plea, then he would have to sit here over the weekend before we could even request for him to have another court date.
Or he could have shown up to court.
Yes, Your Honor.
I just am not comfortable accepting the plea, given that he failed to appear. So, maybe.
I can't afford bond. I just lost my brother yesterday. He was shot to death. My grandmother died the week before that. That's why I didn't come to court. I had 2 losses in my family. My family needs me right now. I have my child. It's one day. It's usually a one-day thing for trespassing.
Alethea Rivers for the state of Florida. The defendant could have made the court aware of his losses, and I'm sure the court would have been amenable to resetting his plea date. So the state would just ask that the bond stay set and what the court has already ordered be continued.
33 days before trespassing, and I was ROR'd on it. Trespass is usually a 1 day for 40 days. Because they don't have information about trespassing for the next day. Usually guys who get caught with beers and things like that, they're released the next day. It's trespassing.
Given that it's an existing warrant, I'm not going to change it. Thank you. I'll take no action on the felony case. All right, thank you, sir.
So, what's your determination, sir?
I'm sorry?
Your determination is what?
Since there's still a warrant, I'm not going to change it. But I'm going to take no action on the felony case.
No action on the felony case, and my bond is still at 2,000?
Yes, sir.
And the court that had my previous case will have to deal with this?
Yes.
Thank you, sir.
Thank you. It's not crazy. You know I can hear him.
Jessica Haber. Oh, 306, 1995.
I'm sorry, one more time.
0306, 1995.
All right, Ms. Heber.
Yes, sir.
I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You're here on driving with license suspended or revoked. I'm going to find probable cause for that charge, release you PTR. Order you not to operate a motor vehicle without a valid driver's license. PTR.
You're good? That's it?
Mm-hmm.
Yes, okay. Thank you.
Sir, your name and date of birth, please.
Good afternoon, Frankie King, 11387.
All right, Mr. King, I'm going to appoint Ms. Cunningham and her office to represent you on this matter. You are here on DUI. Reviewed the affidavit, find there is probable cause for that charge. Or you're released on $500 bond. No drugs, alcohol, or other controlled substance without a prescription. Okay? Thank you.
$500 bond.
Next.
Ralph Atkins in the hospital.
All right, well, medical reset till tomorrow.
Nena Clark is mental health.
Okay. All right, next one.
Jessica Cunningham bonded.
I like what's happening right now. Show your name and date of birth.
Deshaun Jones, April 29th, 1985.
All right, Mr. Jones, I'm going to appoint Ms. Cunningham and her office to represent you on this case. You're here on a trespass on property after warning. I reviewed the affidavit. I find there is probable cause for that charge.
Your Honor, does the court have an offer for that charge?
State?
The state doesn't have an offer, but the state is not opposed to the court giving an offer in the case.
Is this accurate that his last conviction was yesterday on a trespass?
Your Honor, I believe he's here for 2 cases.
Yeah, he's here for 2 cases.
Oh, I'm
but
sorry.
He did, they did adjudicate him guilty
Yesterday.
yesterday.
Okay, my offer would be an adjudication of guilt. Give him 5 days credit per time he's already been in.
Yes.
And Your Honor, is that for both the open container and the
Yeah.
trespass? Yes?
Yes, yes.
Your Honor, he stated he'd be willing to take that offer at this time.
All right, raise your right hand for me, please. Do you solemnly swear or affirm testimony you're about to give in this matter to be the truth, whole truth, nothing but the truth, so help you God?
Yes.
All right, what's your name?
Deshaun Jones.
All right, well, let me get to my list here. All right, how far did you go in school, sir? How far did you go in school?
Oh, 11th grade.
All right, are you being treated for mental illness?
Not right now.
Have you ever been treated for mental illness?
Yeah.
Okay. When was it, and are you currently under a doctor's care?
It was, I was trying to get some help. I was homeless at the time, trying to get some help. And, no, not right now, no.
Okay. Are you under the influence of any alcohol, narcotics, or medication?
No.
So the plea would be you would plead guilty for an adjudication of guilt, and in 5 days in county jail with court costs. You understand that? Okay. Do you did you discuss it with your lawyer? That's that lady sitting next to you.
Do you have any?
Did you discuss it with your lawyer, the lady standing next to you?
Oh, yeah, I understand.
Okay. Were you promised anything in return for your plea?
No.
All right. Do you understand you're giving up some constitutional rights?
Yeah.
Okay. Understanding that you're giving up those rights, you wish to proceed?
Yes.
All right. Are you satisfied with the services of your attorney?
Yes.
So, as a factual basis, state.
Your Honor, if you would like, the defense would stipulate to a factual basis for the purposes of a plea.
All right, perfect. To the charges of trespass on property after warning and of alcoholic beverages open container, how do you plead?
No contest.
All right, so I'm going to accept your plea of no contest. I'm going to find that you, defendant freely, voluntarily, and intelligently waived his right. He entered the plea and understands the natures of the plea and the consequences of the plea. I find the defendant competent, coherent, and alert, and I find that there is a factual basis for the plea. The court will adjudicate him guilty and sentence him to 5 days plus court costs. Year? You want a year?
Huh?
Yes, Your Honor.
Right, with a year to pay the court costs. All right, thank you, sir. Name and date of birth, please.
Name and date of birth.
Andrew Ramdeen, August 1st, 2001.
All right. Sir, I'm going to appoint Ms. Cunningham in her office to represent you on this matter. You are here, excuse me, on one count of criminal mischief. Reviewed the affidavit, find there is probable cause for that charge. Excuse me. Set your bond at $500, order you not to return to the scene. Does he have an open felony?
It was transferred to another case for misdemeanor, petty theft.
Oh. So the CF 61 or 1655 is now MM 1530?
Correct.
Got it.
Your Honor, what was that case number?
22 MM 1530. Has it been filed on?
Yes, Your Honor, that case has been filed on
I'm
and
gonna
is
revoke.
currently set for a trial period.
I'm going to revoke on it. Thank you, sir. Your name?
Annie Catherine Williams.
All right, Ms. Williams, I'm going to appoint Ms. Cunningham in her office to assist you here. You're here for an out-of-county warrant, so the judge in that county Indian River County, set your bond at, is this right, $423.83, is that?
Your Honor, this is out of county. I have no clue.
So your bond is $423.83. So you can pay your bond or we'll let Indian River know.
Okay.
Thank you. All right, next. What's your name, sir?
This is Mr. Ponder.
Jackie Ponder.
All right, Mr. Ponder.
Your Honor, I believe my office was appointed yesterday. There was a probable cause challenge and the state asked for 24 hours.
Alethea Rivers for the state of Florida. The state has not received any further information.
What was the challenge yesterday? I don't have the,
Your Honor, unfortunately,
Transfer.
I wasn't here yesterday.
Alethea Rivers for the state of Florida. I believe the challenge was that there was no indication that the defendant in this case had actually touched or struck the victim against their will.
Hold on.
I agree. All right, so, court will find no PC. So we're ROR, I think technically, no PC on that count. I'm sorry? No contact will remain. Is that what you said? Yeah, no contact. There'll be no contact.
So you're gonna do this?
There's also a charge of,
Oh, but so I can't do a no contact, right?
I don't,
It's still open.
I don't,
What do people do with other?
you're being released. He's saying that. Hold on 1 second. You need to put, I'll put it back on when you get.
Right.
You're being released.
No, my paperwork. Is there a question?
He just was confused as to what was happening, Your Honor.
That he does has a charge for violation of probation.
He has an additional charge?
I'm just gonna, we can address that separately.
Okay, and he had reporting requirements for a high-risk sex offender, yeah.
I'm sorry, what's the case number for his?
They have 2104494.
So it's out of county?
I'm double checking right
You said something about, Almonte?
We're talking about Ponder. I'm sorry, Your Honor, I'm inquiring about Ponder because it's being stated that he's also has a violation of
now.
probation?
Yeah, well, because he's a high-risk sex offender and a violent offender.
Uh-huh.
So he had reporting requirements once he get, that's what I was trying to tell the judge, for that violation of probation.
So that needs to be a condition? I'm confused as to.
So was he on 2 cases or 1?
Because I see 2 charging affidavits.
Okay, so he might have been here on 2 cases. But was one addressed yesterday?
Yes.
I don't know, that's what I'm trying to figure out.
That was the one that they had reset. That was
The one they reset was just on the dating violence.
right.
But was the other one addressed yesterday?
Because the charge, the dating battery charge came in the 26th. Then I guess he got violated on yesterday.
So
He's still not getting out, I
Is that what you're saying?
But they just have it as a charging affidavit. Like they charge him for violating his probation.
Okay, because I don't see any open cases for him. I don't.
Let me look. Are you talking about 21 CF 4494?
Your Honor, it looks like the arrest for the battery, which you found no PC on, I believe it was an on-site violation of probation.
There is an affidavit for violation of probation filed May 27th, but it's not before me in my paperwork, so.
Okay, that's what I was confused about.
I'm not going to address it today. I don't have it. So maybe he'll be brought up tomorrow on that.
Okay.
I don't know. But you're right, there is an affidavit for violation.
So if he's being held on it, I would think he needs to be in front of the judge by tomorrow.
Right. Because he's also being held on the violent offender.
Yes, as a hold.
Yeah.
Are you asking me to on-view him? Is that what you guys are doing?
No.
Okay. Okay.
No, he should be back tomorrow.
All right. What is your name, ma'am?
Gina DeBaradinas.
All right, ma'am. I'm going to appoint that young lady sitting next to you, that's Ms. Cunningham, to be your attorney on this case. You're here on 1 count of alcoholic beverages, open container. Find that there is probable cause for that charge.
Your Honor, does the court have an offer for this case?
Does the state have an offer?
Well, it's a city case, so I didn't ask them.
Yeah, they wouldn't. Let me look real quick.
You have a disorderly intoxication.
Like 6 years ago?
1 year ago. 2021.
Oh, you got that one?
Yeah, my offer is time served and a withhold.
I'm sorry, Your Honor?
Time served and a withhold. with
Okay,
court
may I have
costs.
1 moment?
Your Honor, we'd like to take that offer at this time.
All right. Raise your right hand for me, please. Solemnly swear or affirm testimony you're about to give in this matter to be the truth, whole truth, nothing but the truth, so help you God. All right. What's your name and age?
Tina DeBardinas, I'm 49 years old.
All right. How far did you get in school? Thank you.
I have an associate's degree.
You can put your hand down, by the way. Have you ever been treated for a mental illness?
I have not.
Okay. Are you under the influence of any alcohol, drugs, narcotics?
No.
All right. So the terms of the plea would be a withhold of adjudication and then credit for time served and court costs. Do you understand those terms?
Yes, sir.
All right. Have you had a chance to discuss them with your lawyer?
Yes.
Okay. Anybody promise you anything other than what you were just offered? Okay. Anybody forcing you into your decision?
No.
Do you understand you're giving up some constitutional rights such as right to a trial, right to not incriminate yourself, et cetera? Right? You wish to proceed knowing that you're giving up those rights?
Yes. Yes.
Are you satisfied with the services of your attorney?
Yes.
Okay. Are the parties stipulating to the facts?
Yes, Your Honor.
All right. So the charge of an open container, how do you plead?
No contest, she said.
All right. I'm going to accept the plea. I'm going to find that you are freely, voluntarily, and intelligently waiving your rights, that you are knowingly entering to the plea and understanding the nature and consequence of the charge, and that you are competent, coherent, and alert, and that there is a substantial factual basis for accepting your plea. So I'm going to sentence you to credit time served, withhold adjudication of guilt, and order you to pay court costs over the term of 1 year. Okay? So thank you.
Thank you, sir.
Thank you, Your Honor.
That's the one that just was. Time served. That's the last one, right? All right.
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Your Honor, we're ready when you are.
Just give us one quick second.
Just
read first before I come up.
And I know you, but what's your name again?
Was not coming that way, you know.
Madam Osceola, ma'am?
I'm sorry. Are you
This
asking
is-
who I am?
Yeah, what's your name?
Can't hear.
What, yeah, I know you, but what's your name?
Michelle Quintano.
For his behavior.
I knew that.
6'4".
I knew that.
I'm pretty sure that's the response. You know, I'm pretty sure. So it's not coming. That's it. The one that you already see.
Oh,
Yeah.
okay.
At the hospital one, it's already there and everything, so.
Perfect.
It was a little bit, should be here.
Okay, thank you.
There, one second. So, hey guys. Thank you. All right, so we are on the record. It is Saturday, May 28th, 2022. Here for currently Osceola County. Initial appearances, 9th Circuit. I'm Circuit Judge Diego Madrigal. I'll be presiding today. Let's go ahead and get appearances. We're going to start with the state.
Alethea Rivers for the state of Florida.
PD?
Michelle Quintano for the defense, Your Honor.
All right, and
Your
do
Honor,
we have,
I do have a couple Spanish, before you, I'm sorry, a couple Spanish and a couple refusals, okay?
okay, just tell me the Spanish now.
You wanted me to tell you now?
We're going to call them at the end, but just tell me now so we
Okay,
can.
Spanish is Padilla, Xavier. And last name is Rodriguez Calderon. First name is Elinette. Those are the two
Oh,
Spanish.
okay, I know that one. Okay. And then, do we have PTR down there?
Joy Gibson with pre-trial release.
All right, thank you. All right, so first one we have is Omar Abdelal.
Yes, Your Honor, he's in the cage. They have to get him.
Your Honor, if you need a copy of that warrant, I can email it to the clerk.
I'm good. I read it last night on something else. The audio is much better than the last time I was here.
No, he's got to come up here. They have to get him
Your
out.
Honor, can you talk to the inmate in the cage?
I'd like to see them.
Can you see him back there?
I cannot. I can only see the cage that's behind. There's a gentleman sitting alone in the last row. That's the only cage I can see. Yeah, the guy who just turned around. That's the only cage I can see on the far right. My far right. Right, your far left.
Yes, sir.
Do we want to just call him last? Would that make it easier?
Well, he has co-defendant, Your Honor, so they have to bring him out and bring the co-defendant in. So I don't know if you want to call him last. He'll be waiting for the co-defendant.
Okay. Whatever's easier for y'all. I don't.
They're getting him out in the cage, sir.
Okay. I just have to be out of here by 9 p.m. Is that what we said? 9 p.m.
He's present and approaching, Your Honor.
All right. Morning, sir. Your name and date of birth, please.
Good morning, Omar Abdel, 11/29/2001.
All right, Mr. Abdullah. Hope you're doing well. I'm going to appoint the young lady sitting next to you, Ms. Patino, and her office to represent you in this matter. You're here on 3 counts. Another judge has already found probable cause for those. Do you want me to read the charges, Ms.
No,
Patino?
Your Honor, we'll waive the reading of the charges.
Okay. So another judge has already found probable cause. I'm going to set no bond on these charges. Order you to have no contact with your co-defendant, no firearm, weapon, or ammunition, and no return to the scene. All right. Thank you, sir. Well, no contact with the co-defendant and the victim and their families, I guess. It's just an assumption. All right, I got Dylan Baskaki? It's cocky. Dylan Baskaki?
So, Your Honor, we're having a hard time.
Yeah, I was over here. I wasn't close to the
okay,
mic.
sorry.
I'll adjust.
Okay.
Sorry, that was on me. All right. Morning, sir. Your name and date of birth, please.
Dylan Boxkoki, 2/12/1995.
All right, Mr. Baxkoki, I'm going to appoint Ms. Patino and her office to represent you on this matter. You're here on 2 counts. First count is battery. Second count is criminal mischief, $1,000 or more. I've reviewed the arrest affidavit. I do find that there is probable cause for those charges. I am going to I'm going to set your bond as follows. I'm going to do $100 with PTR on both counts. Order you to have no contact with the victim, not return to the scene, not possess any weapons, ammunition, or firearms. And to I think maintain separate residence, if I'm not mistaken. You live together?
Yes, we live together.
All right, so maintain separate residence as well. Allow one-time return with law enforcement to retrieve personal belongings.
Okay.
All right, thank you, sir. 100 with PTR on both counts, the conditions on both counts as well. 100 each with PTR. Yeah, sorry. I didn't make that clear. It's 100 each with PTR. And is it Patino? Am I saying that right? Is it Patino? Is that
Michelle Quitano, yes.
Patino or Patino?
Quitano.
Quitano. Oh,
Quitano, yes.
I'm butchering it completely.
It's okay, they used to call me Potato, but it's Quitano.
Quitano. Okay. Mr. Braddock Tawala. All right, sir, your name and date of birth, please.
Rahul Braddock Swallow, 9/12/2000.
All right, Mr. Braddock Tawala, I'm going to appoint Ms. Quitano and her office to represent you on this matter. You're here on 4 counts. First one is possession of marijuana over 20 grams. Second one is possession or use of drug paraphernalia. Third and fourth are the same, possession of controlled substance without a prescription. I reviewed the arrest affidavit. I do find that there is probable cause for all those charges. I'm going to issue you a bond on count 1, $2,500, count 2, $500, counts 3 and 4, $2,500 each. Your total monetary bond will be $8,000. Additionally, I'm going to order you to not have any controlled substance without a prescription. Is he out on bond on a case?
Yes, sir. Osceola case.
Okay. I'm going to revoke your bond on case 2021 CF 2803.
Can I get a new bond on that case?
All right. Thank you, sir. The next one I have is Noemi Cruz. Morning, ma'am. Your name and date of birth, please.
Good morning. Noemi Cruz, January 10, 1982.
All right, Ms. Cruz, I'm going to appoint Ms. Quitano and her office to represent you on this matter. You're here on 1 count of battery. I have reviewed the arrest affidavit. I do find that there is probable cause for that charge. She doesn't qualify for PTR?
Not at this time, Your Honor, because we couldn't verify her history with Florida.
All right, I'm going to order you be released ROR. That means there's be no monetary conditions on your release, but I am going to put conditions on it. You're going to have no contact with the victim. You're to consume no drugs, alcohol, or other controlled substance without a prescription, and you can't possess any firearm, weapons, or ammunition. Okay?
That's fine. Do I have to come back for a court date? I live in Pennsylvania. I want you to be able
I'll even allow you to return to Pennsylvania.
Thank you. I leave tomorrow.
But you do have to come back for a court date.
That's a second advantage. Yeah.
So,
Absolutely.
yeah, just you see that young lady standing next to you? That's your lawyer. Talk to her about stuff, okay? All right, thank you. Jerry Cumbus.
Your Honor, we'd like to waive the reading of the charges.
All right, your name and date of birth, sir?
Jerry Cumbus, 3/25/83.
All right, Mr. Cumbus, I'm going to appoint Ms. Quitano and her office to represent you. You're here on 4 counts. I've reviewed the arrest affidavit. I do find there is probable cause for those. He qualifies for direct PTR?
That's correct, Your Honor.
All right. Any objection from the state?
No objection from the state.
All right, so I'll order you be released on direct PTR on each account. And I'll put no other conditions. Thank you, sir. All right, Jonathan DePerna.
Your Honor, Mr. DePerna refused to come.
All right. All right, you want to reset till tomorrow?
Yes, Your Honor.
All right, we'll reset Mr. DePerna till tomorrow. Kevin Gamboa. If appointed, are you waiving reading as well, or?
Can't hear what he said. Your Honor, I can't hear what you're saying. I'm sorry.
I said, if appointed, are you waiving the reading?
Oh, yes, Your Honor. I'll be here tomorrow. Yes.
No, for Mr. Gamboa. If you're appointed for Mr. Gamboa, will you?
Are you talking about Mr. Gamboa?
Yeah.
Yes, Your Honor. Sorry.
Okay. All right, name and date of birth, sir.
My name is Kevin Gamboa, March 3rd, 1998.
All right, Mr. Gamboa. I'm going to appoint Ms. Quatania in her office to represent you in this matter. You're here on 2 counts. I've reviewed the arrest affidavit. I do find there is probable cause for those charges. I'm also going to release you direct PTR with no other conditions. All right, so thank you. All right, Michael Hartman. All right, sir. Name and date of birth, please.
Michael Scott Hartman, 102784.
Mr. Hartman, I'm going to appoint Ms. Quatania in her office to represent you on this matter. You're here on, I have two different cases.
I believe it's 2 different cases, Your Honor.
Okay. So 4 counts total?
Yes.
Okay. So you're here on 2 different cases. On the first case, you're facing 2 charges. I've reviewed the arrest affidavit. I find there's probable cause for those charges, which are driving with your license suspended or revoked, third or subsequent violation, and fleeing and eluding a law enforcement officer with lights and sirens active. On the second case, I've reviewed the arrest affidavit. I do find there's probable cause for possession of drug paraphernalia, count 1, and then the second count, possession of a controlled substance without a prescription. I am going to issue you monetary bond as follows. On the first case, the driving with license suspended, third or subsequent offense, $2,500. On the fleeing and eluding law enforcement with lights and sirens activated, $2,500. On the second case, the possession, $500. And on the third count, the possession of the controlled substance without a prescription, $2,500. So your total monetary bond will be $8,000, $5,000 for the first case, $3,000 for the second case, along with the following conditions. No operating a motor vehicle without a valid driver's license. No possession of a controlled substance without a valid prescription. And that'll be it. Thank you. Jose Marti Duran.
Your Honor, the defense would like to waive the reading of the charges, please.
Okay. All right, sir, name and date of birth?
Jose Marti, July 31st, 1968, sir.
Jose Marti, wasn't that a poet?
Yes, sir.
Yeah. Yo soy un hombre sincero de donde viene la palma. Yeah. So you guys see, I know poetry too. I'm going to appoint Ms. Quateno in her office to represent you on this matter. You're here on 2 counts. I've reviewed the arrest affidavit. I do find there is probable cause for those. I'm going to release you direct PTR on both those counts.
Thank you, sir.
Thank you. Laura McCoy.
We start. Good.
Okay. And we have somebody here to testify on this one. Okay. Ma'am, name and date of birth, please.
Laura McCoy, 331-78.
All right. Ms. McCoy, I'm going to appoint Ms. Quatenio in her office to represent you on this matter. You're here on one count of battery. I have reviewed the arrest affidavit. I do find that there is probable cause for that charge. Morning, sir.
Good morning.
What's your name?
Mark Hayes.
Mark Hayes?
Hayes, Hayes.
All right, sir, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, Mr. Hayes, what's your relation to this case?
We are engaged.
Okay. Oh. You're also the victim?
I am.
Okay. Mr. Hayes, so I've already found probable cause for the charges, so a lot of people come in and want to tell me what happened. I don't really want to know about that. I just want to know about the conditions of the release. So I'm going to ask you a couple questions. Are you scared of her?
No, absolutely not.
All right. Do you want to have contact with her?
If she will have contact with me, yes.
Well, so it's kind of your decision right now.
I'm fine with it, yes.
Okay. Do you want her to return to the home?
Yes,
Okay. If something like this were to happen again, would you call law enforcement?
absolutely.
Are you, I think I already asked you this, are you scared of her in any way?
No, I'm not. This is very out of character for her, for both of us.
Okay. State, any further questions?
Has there been any prior instances of domestic violence between the two of you?
No, never has.
No further questions.
Ms. Catania?
No questions, Your Honor.
All right, so I'm going to order she be released on $100 bond with PTR. She's to have no hostile contact with the victim. That means you can't hit them, yell at them, throw stuff, none of that. I'm also going to ask you not to drink, no, not ask you, order you not to consume any alcoholic beverages or other controlled substance without a prescription. And I'm going to tell you you can't have weapons, ammunition, or firearms. Okay? So, anything else from defense?
Nothing from the defense, Your Honor.
All right, anything else, Mr. Hayes?
Only that she and I live out of state, and she is here on an assignment as a nurse, and her contract is over. She'll have to leave next week.
So I'll allow her to travel out of state. She has to keep in contact with PTR, though, reach our release. Can you hear me okay, Mr. Catania?
Yes, sir.
All right. I'll try to enunciate more. All right. So thank you, ma'am.
Okay, you're done.
All right, thank you, Mr. Hayes.
Thank you.
Leon McCrimmon.
Your Honor, the defense would like to waive the reading of the charges.
All right. All right. Morning, sir. Your name and date of birth, please.
Good morning, Liam McCrimmon, 6/30/81.
All right, Mr. McCrimmon, I'm going to appoint Ms. Quatenio and her office to represent you on this matter. Okay?
Yes, sir.
What's happening over there? You figure out, what are you guys doing?
Sorry, Your Honor. That young man's with me, and the deputy was gesturing as what I wanted to do. That's why I went to the door.
Okay, is he a lawyer?
No.
Okay, then he's got to stay out there for now. Is he a student?
Yes.
Like a law student?
No.
Like an intern?
Going to law school. Yes.
He can come in if he wants.
I'm at the 11 o'clock docket, Your Honor.
I know.
We don't have a key for it.
Oh, you don't have a key for him? Oh. Then he's got to wait out there. Sorry.
That's all right.
All right. So I'm going to appoint Ms. Quatenio and her office to represent you on this matter. You're here on 5 counts. I've reviewed or another judge reviewed the affidavit, found probable cause. I'm going to issue you a bond of $2,500 each count. So that'll be a total of $12,500. I'm also going to revoke your PTR on case 22 CF 1259.
Your Honor, it's a bond with PTR, you're revoking the whole thing?
I'm revoking the whole thing.
Okay, thank you.
Thank you. All right, thank you, sir. Okay, Pedro Rodriguez. Wait, did I? Nope, I'm just kidding. I have a different order. Who do you have next?
Cedric Mills.
Okay. That's, yeah. All right, Cedric Mills. All right, sir, your name and date of birth, please.
Cedric Mills, 9/26/92.
All right, Mr. Mills, I'm appointing Ms. Quintana in her office to represent you. You're here on a failure to appear on a written promise. So Judge Nix Walker has issued a warrant, set your bond at 0, so I'll keep it that way. Thank you. Xavier Padilla.
Your Honor, he's a Spanish case.
I'm sorry?
Spanish.
He's a Spanish case.
Oh, all right. We'll recall him.
They're gonna call you. They're gonna, you're set.
And then the next one, Rodriguez, is that also a Spanish?
No, Your Honor. Pedro Rodriguez is not Spanish.
All right, Pedro Rodriguez. Is her name and date of birth, please?
Pedro Anthony Rodriguez, March 13, 1976.
Your Honor, the defense would like to waive the reading of the charges.
Okay. Wait till you're appointed, by the way. I'm going to appoint Ms. Catano in her office to represent you on this matter. You're here on one count. Another judge has already found probable cause. Wait. Yes. Hold on a second. Yeah, another judge has already found probable cause. I'm going to release him direct PTR. All right, thank you, sir.
Thank you.
Your Honor, Rodriguez Calderon is also Spanish interpreter.
Okay. Thank you. Jose Rodriguez Vega.
She told me she needs one.
Sir, your name and date of birth, please.
Jose Rodriguez, 6/10/1993, Your Honor.
Okay, I'm going to appoint Ms. Quintanilla in her office to represent you. You're here on a violation of probation. Judge Young has already found probable cause on that. He set your bond at 0, so I'll stay that bond.
Thank you, Your Honor.
Thank you, sir. Michael Sanchez, Santiago.
He's in the cage, Your Honor.
He's about to come.
Okay. Okay.
They're getting him out.
If appointed, you're waiving? Question?
Yes, Your Honor.
Okay. All right, sir, your name and date of birth, please.
Michael Sanchez, 11/15/99.
All right, sir, I'm going to appoint Ms. Quintana in her office to represent you on this. You're here on a warrant, so another judge has already found probable cause for one charge. Can I get a history PTR?
He only has 2 prior charges dating back to 2018, resisting without violence and procuring for prostitution in 2021.
Okay. I'll stay the bond on the warrant. I'll stay the bond on the warrant. That's $25,000. Were there any conditions on? I don't have a copy of the warrant. So. All right. I'm just to do no contact with the victim or anybody similar. And I'll explain what that means to you in a second. Yeah, so no contact with the victim, their family, or anyone in similar circumstance. All right, thank you, sir. That's what I meant. All right, Ellis Hardwick? Or do you have Marcus Sims next? Or do we already do Marcus Sims? Huh? Marcus Sims? Marcus Sims. Marcus Sims? All right. Morning, sir. Your name and date of birth, please. Can we bend that down a little bit? Yeah. And you might be muted.
Sorry, yep. One more time. One more time.
Marcus Sims, 7/23/91.
All right, third time's a charm. Mr. Sims, I'm going to appoint Ms. Coutinho in her office to represent you on this. You're here on a failure to appear at an arraignment for petty theft. Judge Epperson issued a warrant, set your bond at 0. I'll stay that bond. Jocelyn Vargas? All right, Jocelyn Vargas?
She's approaching, Your Honor.
Okay.
Good morning, Your Honor.
Morning. How are you?
I'm thank you.
All right, what's your name?
Jocelyn Vargas,
And when were you born?
July 11th, 1973.
All right, Ms. Vargas, I'm going to appoint Ms. Quintano in her office to represent you. You are here on a warrant. Judge Nix Walker issued a warrant. She found probable cause for failing to appear and set your bond at 0. I will stay that bond. Thank you, ma'am.
Thank you.
Luis Vigo Santiago. Can I start your name and date of birth, please?
Luis Vigo Santiago, 8/23/73.
All right, sir. I'm going to appoint Ms. Catano in her office to represent you. You are here on a violation of probation warrant issued by Judge Epperson, who found probable cause. Set your bond at 0. I will stay that bond. And I have Ellis Hardwick.
Refused, Your Honor.
All right. I might see him tomorrow. I might not. All right. Any other than the Spanish language?
There's only 2 with Spanish, Your Honor.
Right, but I just want to make sure I didn't miss anybody. Okay. Yeah.
He didn't call the 2 Spanish yet.
Which one was?
Your Honor, he knows that, though. Your Honor, you know you didn't call the Spanish, right? What is he doing? Oh, he did. Can we get him back? He didn't call the Spanish, right? That's the only one? Everyone else is called? Is there anyone that was not called besides her? Okay. Did they call you? No, they pushed him back because it's Spanish. Yeah. Everyone else, just those 2.
Gonna pop up there.
Hello, Your Honor.
You miss us?
I did miss you. Just the 2 Spanish. I didn't know if you remembered that. You didn't call the 2 Spanish.
No, I know. I was calling the interpreter. Could you hear the interpreter or no?
Well, we lost connection, so we didn't hear anything.
Okay. All right. So I call from this one. All right. They shouldn't give me two options on how to do that.
Good morning once again, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have not been sworn today, Judge.
All right, Rafael, can you raise your right hand for me, please?
Certainly, Your Honor.
All right. Do you solemnly swear or affirm to translate from English to Spanish to English to the best of your ability, so help you God?
I do, Your Honor.
All right. You know, I saw you crossing the street yesterday. I almost hit you.
Oh, that wouldn't have been good. Then
Just kidding. I didn't
help you this
honk
morning.
at you. I almost honked at you. All right. So the first one we have is Xavier Padilla.
And, Your Honor, to the extent that you do have case numbers, if you could kindly provide them for the interpreter, please.
Sure. And I think we have 3 case numbers for this young man.
3 cases, 1 case number.
1 case number? Which one is it? Just give me 1 second.
Certainly, Your Honor.
All right. All right. Case 22 CF 942.
Thank you, Your Honor.
All right. All right. All right. Good morning, sir. Your name and date of birth, please.
Buenos días, caballeros. ¿Me puede dar su nombre y su fecha de nacimiento, por favor?
Xavier Vázquez Padilla, 17 de septiembre del 83.
Javier Vázquez Padilla, 17th of September, 1983.
Okay, Mr. Padilla, I'm going to appoint Ms. Quinteno in her office to represent you on this matter.
Señor Padilla, voy a designar la licenciada Quitano y el bufete de ella para que los represente usted en este asunto.
You're here on
I can't hear you very well.
me or the interpreter?
¿No me escucha a mí o no escucha al intérprete?
Que no escucho bien, no escuché bien lo que dijo.
I couldn't hear very well what he was saying.
Ms. Quinteno, can you clarify if he means me or if the connection with the interpreter is bad?
Licenciada Quintana, ¿puede usted confirmar si es la conexión conmigo o si no escucha al intérprete?
No, que no se escucha bien acá,
You can't hear it very well over here.
Okay. Maybe we'll just speak louder.
Vamos a hablar un poco más fuerte entonces.
You're here on 3 cases.
Usted se encuentra aquí presente en 3 casos.
The first one is for failure to appear on a written promise.
El primero es falta de comparecencia, una promesa escrita.
Second one is possession of or use of drug paraphernalia.
El segundo es poseer o usar parafernalia de drogas.
The third one is driving with license suspended or revoked.
Y el tercer cargo es conducir con licencia suspendida o revocada.
Second or subsequent offense.
Segundo o subsecuente delito.
All right. On the first case,
En el primer caso,
a judge has issued your warrant for failing to appear.
un juez emitió una orden de arresto por una falta de comparecencia
Set your bond at 0.
y no tiene derecho a fianza en este momento.
And I will stay that bond, so it'll stay the same.
Lo dejaré tal como está, no tiene derecho a fianza en este momento.
On the second case,
En el segundo caso,
the possession or use of drug paraphernalia,
poseer o usar parafernalia de drogas.
I've reviewed the affidavit. I find that there is probable cause.
He revisado la affidavit y determino que existe motivo fundado.
I will set your bond at 500.
Voy a programar su fianza en 500.
I'll order you not to possess any drugs, alcohol, or other controlled substance without a prescription.
Le ordeno que no posee drogas, alcohol o sustancias ilícitas sin tener receta.
On the third case, the
El
driving
tercer
with
caso,
ended.
conducir con licencia suspendida.
I've reviewed the arrest affidavit. I find that there is probable cause.
He revisado la affidavit del arresto, determino que existe motivo fundado.
I will set your bond at $500 and order you not to operate a motor vehicle without a valid license.
Voy a programar su fianza en $500 y le ordeno que no conduzca un automóvil a que no sea que tenga una licencia válida de conducir.
Ok, mira, ¿puedo decirle algo?
Okay, can I tell him something?
Tell your lawyer first.
Dígaselo a su abogado primero.
Your Honor.
Okay. Do I need to advise him of his Fifth Amendment right, or is he not going to say anything?
¿Necesito avisarle de su derecho bajo la quinta enmienda o sí, su señoría?
Okay. Mr. Padilla, you have a Fifth Amendment right to remain silent.
Señor Padilla, usted tiene un derecho bajo la quinta enmienda de permanecer en silencio.
These are audio recorded proceedings, and there's a state attorney, a prosecutor sitting here listening to everything you're going to say.
Estos procedimientos se están grabando de manera de audio y hay un fiscal presente que está escuchando todo lo que usted diga.
If you wish to waive that right to remain silent, you may do so now.
Si usted quiere renunciar su derecho a permanecer en silencio, lo puede hacer en este momento.
Yo quisiera decirle algo, viste, porque yo
Well,
salí-
I'd like to say something, you know, because
The defense suggests you don't say anything.
la defensa le sugiere a usted que no diga nada en
You can
absoluto.
talk to your
Sí,
attorney.
pero yo quiero decir algo porque es
Ya,
algo
usted puede hablar, señor, un momentico. Your Honor, if I can instruct the defendant
You may.
to wait for the
You may.
interpretation.
You may.
Señor, por favor, no hable hasta que el intérprete no termine de interpretarle. Counsel, if you be kind enough to repeat your last statement for the
Sure, I
to the
would just
defendant.
advise him not to speak at this time. He can talk to his attorney.
Le estoy aconsejando que no hable en este momento, que mejor hable con su abogado.
Es que yo lo que quiero decirle es algo que me pasó porque yo salí de la cárcel el miércoles, fiado de ese caso.
Momentico.
no
I
tenía
just want to
disco-
say something. I just got out of jail on Wednesday on that case.
On the failing
tenía
to
día de
appear?
corte.
Por el falta de comparecencia.
No, yo salí el miércoles de la cárcel fiado de ese caso que tengo el guarante. Y a mí nunca el abogado de asistencia legal me vino a buscar. Y cuando yo salí... que firmé los papeles-
Momentico. Your Honor, I'm just instructing the witness to wait for the interpretation. I got out of jail on Wednesday on a bond and for that case with the warrant, and the attorney never came. Adelante, señor.
Okay. There's no bond on that case, so I'm not sure what you're saying, but good news is
Bueno, ese caso no tiene fianza, si es que no sé a qué se está refiriendo usted, pero la buena noticia es
you can bring it up with the trial judge who issued that warrant,
pero eso usted lo puede tramitar con el juez del caso que emitió la orden
and it can all get straightened out at that time.
y todo se puede resolver en ese momento.
Y yo tengo día de corte, el número.
Do I have a court date, a number?
We have a case number if you'd like.
Tenemos un número de casos si usted lo desea.
Yo necesito el día de corte porque en verdad yo nunca supe el día de corte mía. Y yo y la fiadora que me fió tampoco tenía día de corte.
Momentico. I need my court date because I didn't have a court date, and the bond person, she never had a court date either.
This is what you should bring up with the trial judge, the trial court judge that issued the warrant.
Eso es algo que usted tiene que tramitar con el juez del caso, el que emitió la orden de arresto.
Okay. All right. Thank you, sir.
Gracias, caballero.
I hope it all gets straightened out.
Espero que todo sea resuelto.
All right, the next one I have is Elinette Rodriguez Calderon.
And, Your Honor, do you have a case number for this defendant?
I do. 22 CF 1358.
Thank you, Your Honor.
All right. Morning, ma'am. Your name and date of birth, please.
Buenos días, señorita. Su nombre y su fecha de nacimiento, por favor.
Buenos días, Elena Rodríguez Calderín, octubre 14 del 1994.
Good morning, Elinette Rodriguez Calderín, 14th of October, 1994.
Okay. All right, ma'am. I'm going to appoint Ms. Quintana in her office to represent you.
Bueno, señorita, voy a designar las oficinas de la licenciada Quintana que la represente a usted.
All right, you're here on a warrant issued by another judge.
Usted se encuentra aquí presente por una orden de arresto que fue emitida por otro juez.
All right. That charge is armed robbery with a firearm.
Eso es un cargo de robo a mano armada con arma de fuego.
So that judge has already found probable cause.
Ese juez ya determinó que existía motivo fundado.
Is she entitled to a bond, State?
Fiscalía, ¿ella tiene derecho a fianza?
One moment.
Un momento.
Defense, I'll ask you the same question. Do you know what the maximum penalty is?
Defensa, le pregunto lo mismo. ¿Sabe usted cuál es la pena máxima?
What was your question, Your Honor?
Do you know what the
¿Cuál fue su
maximum
pregunta,
penalty
señoría?
is for the charged crime?
¿Sabe usted cuál es la pena máxima por el cargo acusado?
For robbery with a firearm?
Arma de fuego, robo a arma armada.
Yes, ma'am.
Sí, su señoría.
She's not a señoría.
I'm sorry, Your Honor. I got a little turned around. My apologies.
I don't know, Your Honor.
No sé, su señoría.
All right, hold on. Give me 1 second.
Permíteme un momento.
Made any progress, State?
Fiscalía.
Looking.
No, the state could look it up. You don't let us use a computer in here, so. State has their computer.
No. First degree punishment for the years of extended life imprisonment. I'm going to hold her no bond.
Alethea Rivers for the state of Florida.
Voy a mantenerla detenida sin derecho a fianza en este
I'm sorry, Ms. Rivers, did you?
Yes.
It says life, a felony by the first degree punishable by imprisonment for a term of years not exceeding life imprisonment. So it's a life.
Yes, Your Honor, that's correct. That's what the state was calling.
Es un cargo que trae una pena máxima de cadena perpetua. Correcto, su señoría.
All right, so I'm going to hold her no bond.
Voy a mantenerla detenida sin derecho a fianza en este momento.
Thank you, Your Honor.
All right, thank you. Is that the last one?
Yes, Your Honor.
All right.
See you tomorrow.
See you tomorrow. Rafael, sit tight. We're going to go right into Spanish Orange, okay?
Yes, Your Honor, no problem.
We'll try to say your case number first, but let's just, it is Saturday, May 28th, 2022. In Orange County, initial appearances. I'm Judge Madrigal, Circuit Court Judge presiding. Let's go ahead and get appearances once again. We'll start with the state.
Alethea Rivers for the state of Florida.
All right. Defense.
Dominic Cunningham for the Office of the Public Defender.
Sir, which case are you on?
Scott Syverson, Your Honor, on behalf of two defense Ochoa and Lorena.
Ochoa and Lorena. Can we move those up?
B-O-J-E-A.
Can you speak up a little bit? Hold on. I'm going to hang up on you, Rafael, and then we'll call you right back, okay?
No worries, Your Honor. I'll be on standby.
All right.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Any other private counsel or media?
Your Honor, we have the media present for Mr. Lassiter. Come on up.
For, one moment, please.
Good afternoon, Judge.
I'll go ahead and take Mr. Lassiter up, but I would like to go ahead and address the group first before we do that.
Yes, Judge.
Can I have Mr. Lassiter take a seat for a moment, please? Ladies and gentlemen, let me introduce myself. My name is David Silverman, and I am a county judge. I'm here today in the capacity of your initial appearance magistrate. And we're going to be doing several things in your case. Each of you is here as a result of having been arrested for an alleged criminal offense. And when you come up to the microphone in just a little while, the court will advise you as to the nature of the charge that has been lodged against you. The court will make a determination from the sworn arrest report and whatever other submissions are appropriate for the court to consider as to whether there is probable cause for your arrest and detention on that charge. The court will address with you the issue of counsel, because being charged with a criminal offense, you have the right to an attorney to represent you, and if you desire to be represented by an attorney but cannot afford to hire a lawyer, the court, after making the appropriate inquiry, will appoint counsel to represent you. The court will also be making a determination as to the reasonableness of your bond. In order to fulfill those functions, it may be appropriate that I speak to you. But no question I ask and nothing I say should invite you to talk about the case or the facts of your case, because anything you say at this proceeding may be used against you at the trial and at other proceedings in your case. Proceedings here are being taken down by an audio-visual recording system, and there's a representative from the state attorney's office present to take note of any such statements. You have a right to remain silent, and your declining to answer questions or make a statement will not be held against you. If you elect to give up that right and make a statement or answer a question, you have the right to consult with an attorney before doing so. And there's an attorney present. It's Mr. Kennedy, is that right? Fair?
Yes, sir.
Mr. Kennedy, who's with the Office of the Public Defender and with whom you may consult. Now, if the court sets a bond that you are unable to post, you have a right to place a request before your trial court judge to reduce that bond. And you may do that by contacting the attorney I'll be appointing to represent you. You have a right to contact that attorney as well as your bonding agency and your family members by telephone from the jail. At the conclusion of the proceedings, whatever happens in your case, I ask and direct that you accept the paperwork the clerk will generate, and if permitted by the deputy, I direct you sign it. It's not some confession or admission of guilt, but merely the minutes of the proceedings. I would give you notice of your next court date and any bond conditions in your case. If we do speak together today, to whatever extent that we do, it would be important for us to have a meaningful conversation. So I ask and direct that you be sworn or that you affirm to tell the truth in any testimony that you give here today. At this point, would you please stand? And as best you can, would you raise your right hand? Do each of you swear or affirm that any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? Very well. You've been sworn or so affirmed. Let's go up and take up Laquan Lassiter. What is your name?
McCallum, Terrell Lassiter.
Mr. Lassiter, are you aware of the type of charges, misdemeanor charges that have been lodged against you?
Yes, disorderly conduct.
Can you afford to hire an attorney to represent you on this matter?
No, Your Honor.
He qualifies.
I do find probable cause, having reviewed the sworn arrest report, and appoint the public defender. Sig, what's your position on the bond?
$1,000 for each.
I'm sorry?
$1,000 for each count, Your Honor.
I mean,
Defense position.
Judge, I'd ask the court to consider the bonds as they appear on the docket.
I was trying to.
Right. Right, 1,000 is reasonable on each of the counts. 1,000 cash or surety. Conditions: don't consume any alcohol or illegal drugs. What other conditions might you suggest from the state's perspective, Mr. Lockton?
Certainly no return to the location and no contact with any of the individuals that are named in the report.
Mm-hmm. Okay. Don't return to the, it's called the Twisty Treat. It's a restaurant on Wickham Road. Don't go to that restaurant. No contact with any other persons identified in the report. Appear for your next court date, Mr. Lasser, on June 17th, as before Judge Jacobus, as reflected on the paperwork I direct you to sign. Concludes your appearance. Commencing with the take-out of order list. Rodney Archie.
Yes, Your Honor.
Okay. Sir, what is your name?
Rodney Archie.
Mr. Archie, you're here as a result of a warrant issued by a judge in the state of Indiana. You have a right of extradition. Extradition is both a right and a process by which the requesting state, in this case would be the state of Indiana, has time in which to generate the paperwork necessary to establish that there's a legitimate criminal charge pending in Indiana upon which you may be transported there. So they would have, with all the permissible extensions, up to 90 days. However, if you wanted, you could waive that right in that process. If you waive extradition, we would set a date approximately 10 working days off. It would be on June 11th, by which time I expect you would have been transported to Indiana. So my question to you, sir, is did you want that extradition process to go forward, which is the default, if you don't choose otherwise, or did you want to waive that to be sent back there more quickly?
I think I waived it already, Your Honor.
Has he already signed a waiver? Yes, sir. Oh, yes, he has. Very well. Well, aside from what you signed, is that what you want to do?
Yes, Your Honor.
All right, very well. We set the 10-day control date, and you're detained in the Brevard County Jail pending that. But if you're not transported to Indiana, what will happen is you'll be brought back before the judge so that other efforts can be made to make sure you're promptly on your way.
Yes,
Okay?
Your Honor. Yes, Your Honor.
That's it for now. Thank you, sir.
Thank you.
Tashita Green.
Hello.
Hello, Tashita Green, you're here as a result of a warrant issued by a judge in the state of Illinois. You may have heard what I had to say to the gentleman who preceded you to the microphone about the right and the process of extradition. Did you want to that process to go forward, or did you want to waive that and be more quickly transported to the state of Illinois?
I want to be more quickly transported. I
Very
signed
well.
the waiver.
You've signed a waiver to that effect already, is that right?
Mhm.
Very well, and we'll go ahead and set that same control date.
So, Judge, you said they have up to 90 days or 10 days? Because I heard you say something
Well,
about 90.
they would have, here, what they would do is we'd set it to June 11th, by which time I expect you will have already been transported back to Chicago, right? I expect you'll be there by that time. Now, let's say for whatever reason they haven't, there's a bus that goes around to all different states and various places. There's a number of them picking up people, and I expect you'll have been transported. But let's say you haven't been, we brought back before the judge here so that other efforts can be made to make sure you're promptly on your way. Okay?
Okay.
So that's the answer to that. But for the most part, people are transported there by that time.
Okay.
Okay?
All right.
Thank you. Melissa Hare.
Hello,
What is your name?
Melissa here.
I couldn't quite hear you.
Melissa here.
Ms. Hare, you're here as a result of a warrant issued by a judge in the state of Mississippi. You may have heard what I had to say to the two people who preceded you to the microphone there, that Mississippi would have up to 90 days to generate to obtain a governor's warrant to ensure that there's a legitimate criminal charge upon which you can be extradited to Mississippi. If you wanted to waive that, it would be, I expect you'd be transported there more quickly, and we'd set a 10-day control date, June 11th, 10 working days, by which time I expect you would have been transported. So did you want that extradition process to go forward, or did you want to waive that?
I want to waive it.
Very well. And did you sign something to that effect already?
No.
This has a pre-signed
Very well.
paper.
Okay, very well. Then I'd have you remain here at the Brevard County Jail. And if you haven't been transported to the state of Mississippi by the 11th of June, you'll be brought back here before the judge so that the appearance judge here may make other efforts to make sure you're promptly on your way, okay? Thank you. That'll do it for now.
You can leave after lunch tomorrow.
Brings us to Kenneth King. What is your name?
Kenneth King.
Mr. King, you're here as a result of a warrant issued by a judge in the state of Alabama. The requesting state has up to 90 days to generate the paperwork necessary to require you to be transported to that state and to make sure that there's a legitimate criminal charge upon which you'd be facing there. If you wanted to waive that right and be more quickly transported, you can do so, and we would set a date on June 11th, by which time I expect you would have been transported to Alabama. So my question to you, Mr. King, is did you want that right to go forward, or did you want to waive that?
I'll waive that right, and I've signed a paper to that effect.
Has he signed something? Have you already signed that?
Yes, sir.
Very well. Then we'll go ahead and set this also for that same control date, June 11th. And, if something were to be amiss and you were not transported by that time, you'd be brought back before the court here so that other efforts can be made. Make sure you're promptly on your way. That'll do it for today. Thank you. Ashley Lovett. Ms. Lovett, you're here as a result of a warrant issued by a judge in Chatham County, Georgia. And you have the right of extradition, which ensures that there's a legitimate criminal charge upon which you can be extradited back to Georgia. They have up to 90 days to establish that. If you wanted to be transported more quickly, you could do that right. And if you do, I would set a control date on June 11th, by which time I expect you would have been transported to the state of Georgia. And if not, you'd be brought back before the court here so that other measures may be taken to make sure you're promptly transported. So my question to you, Ms. Lovett, is did you want that extradition process to go forward, or did you want to waive that?
I already signed the paperwork for the 10-day.
Okay, whatever you signed, how did you want to proceed? Tell me what you want to do.
I want to as quickly as possible. I do have a job and school, so as soon as possible, please.
All right, very well. Then we'll deem that your waiver is in effect. set that for the June 11th date. And as I say, I expect you'll be, what town is in Chatham County?
Savannah, Georgia.
Savannah. By which time I expect you'll be in Savannah. If not, you'll be brought back here so that the court can order them to pick you up or whatever else would be necessary to do that. Okay? Thank you, ma'am. Alan Sewell.
Afternoon, Your Honor.
Good afternoon. Is it Alan Sewell or Dale Sewell?
Dale.
Dale
Allen.
Sewell, you're very well. You're here as a result of a warrant issued by a judge in Medina County, Ohio.
Medina.
Medina. What city is in Medina?
It's Medina. It's a suburb of Cleveland.
I see. And you have the state of Ohio, the requesting state, has 90 days in which to generate the paperwork necessary to require you to be transported there. And the review of that paperwork ensures that there's a legitimate criminal charge upon which you can be transported. If you want it, you can waive that right and that process of extradition if you wanted, and you would be more quickly transported there. I'd set a control date for June 11th, by which time I expect you would have been transported. So my question to you, Mr. Sewell, did you want that extradition process to go forward, or did you want to waive that?
Well, Your Honor, I just talked to Medina courts 2 weeks ago, and I gave them an offer. They said they were going to get back to me, and they haven't got back to me yet. And then all of a sudden, I got picked up on this warrant. So I'm not sure that they even really want me.
Okay, so how did you want to proceed? My question to you is this. Did you want that extradition process to go forward?
I already signed the
Want to
paper.
All right, okay, I'm not, let's say you didn't sign it.
No, I did
So
sign
let's
it.
start from scratch. If I understand, but if you say to me now, look, I want that process to go forward, I don't want to waive that, I won't hold you to whatever you signed here. I want to know what you want to do.
I want it over ASAP. I'd rather have a bond and drive up there.
Okay, well, so do you want me to set this to get you back as quickly as we can?
Yes, please.
All right. Then I will go ahead and accept your waiver on this. And you signed the waiver previously, but I perceive that you're making that decision at this point. And we'll set that for June 11th, by which time I expect you'll be back in Medina County.
All right.
Ohio. Thank you. Brings us to James Marshall. What is your name, sir?
James Marshall.
Ms. Marshall, let's talk about where we're at on your matters. Okay, there are 3 cases that are before the court. You're already represented by the public defender in 2 of them. And let me tell you my understanding what's going on those 2. You posted bonds on those 2. One was a total of $15,000 in one case, and 1, 2, 3, 4, 5, 6,000 in the other total. And the bonding agency takes the position that they're no longer liable on your bond. So what I would do is I would set new bonds in those cases on the same amounts that you've already posted with the same conditions. Would that seem appropriate to be done as to those 2, Mr. Locker and Mr. Kennedy?
Yes, sir. Yes, Your Honor.
All right, so ordered. Now, there's a new case, however, another charge of violation of condition of release, and can you afford to hire an attorney to represent you in this matter?
No.
He qualifies.
I think it's a fair question, Mr. Marshall. Having posted already $21,000 in bonds.
I didn't post it. The supposable victim, my girlfriend, posted it. That's what I'm saying. This is all crazy. She's going to drop the charges on that class tomorrow, and it's just blowing me away, so I'll just sit here.
Okay. All right. I do find that you qualify for the appointment of counsel, appoint the public defender, find probable cause, state's position on the bonds, on the bond on the new case.
$1,000, Your Honor.
No objection.
that agreeable?
Yes, sir.
Okay, make it 1,000 cash surety. Conditions: no contact with the alleged victim. Obey the instructions that were given to you in the prior case. Do you understand?
Sheriff, yeah.
All right. No contact with the alleged victim. Incorporate the conditions in the underlying domestic violence case into this case as well. Do you have that, Kara?
Yes, sir.
All right, very well. Any other requested conditions state?
No, Your Honor.
Very well. Sir, sign the paperwork clerk will give you reflecting the next court date in each of these matters. Thank you. Laurie Gardner.
Afternoon, Your Honor.
Good afternoon, Mr. Gardner. There appears to be a total of 4 cases.
I don't even understand what any of them are about.
Well, let me take a moment and talk to you about that, okay? There's a misdemeanor case where you're alleged to have failed to appear on a charge of possession of drug paraphernalia, and the judges entered a bench warrant and endorsed $1,000 on that.
Okay.
Now there's a capias. This is something like an arrest warrant that was issued for you, and on that there's charges of burglary of a dwelling, petty theft,
don't know anything
theft of a motor vehicle. Now, don't talk about this yet. I'm just telling you that. Have you hear me out?
Okay, go ahead.
Another charge of grand theft. Now, there's a third case that has very significant new charges. And these are 3 counts of aggravated assault of a law enforcement officer with a weapon or firearm, 3 counts of resisting an officer without violence, and 3 counts of fleeing or eluding officer while the officer is using lights or a siren in pursuit of you. Now, there's also a 4th case that they allege that you were on probation for a misdemeanor, improper exhibition of a weapon, and there's a violation of probation that's alleged, as well as an on-site violation of probation that's alleged based upon these new charges. Now, my question to you, sir, is can you afford to hire an attorney to represent you in these matters?
Nothing at all. I have no money, no nothing.
He qualifies.
Find probable cause and appoint a public defender. State's position on the bonds.
The capias bonds would be what they came in at, Your Honor. The on-site, he is currently on probation for display of a lesser included of display of a deadly weapon, so he's not AMA. But the state would request $5,000 for the VOP. As to the
he was, as I understand it, Ms. Loughran, there was a warrant issued, right? And then there's also an on-site on the misdemeanor VOP. Is that correct?
Let me take a look. I'm not.
What I'd like to ask, Your Honor, is if I was assaulting.
Let's just hold off on that. Look here.
I don't understand why I have warrants for me when I'm not even running nowhere. I'm not trying to escape anything.
You're not helping yourself.
Okay. Ms. Loughran, is it correct that in addition to the on-site, there's a warrant-based violation of probation in Mr. Gardner's what was originally a felony and now is a misdemeanor sort of probation?
And the warrant amounts that, Your Honor.
Okay. The warrant on this case, as I understand it, was endorsed with no bond. And that's, you can see it was issued by Judge McKibben on January 25th. Your position is that notwithstanding the fact that it's a misdemeanor, it should be no bond. Is that correct?
Yes, that is correct.
Oh, I understand.
Then take me back to my cell.
Yes.
Dinner's waiting for me.
I haven't quite ruled yet, and I haven't heard from your counsel.
I'm sick and tired of the games, Your Honor.
What's your position on the bonds and the new charges?
The schedule
new
amount,
felony case.
the $5,000 for counts 1, 2, and 3, 500 for count 4, as far as count 5 and 6, ROR, and count 7, 8, and 9. Let's see, 7 would be 5,000, and 8 and 9 ROR.
Is that's a second-degree felony on counts 1, 2, and 3.
That's correct.
Is that 5,000 or is the bond higher on that under the schedule?
It would be with file, to be 15,000, Your Honor, I'm sorry.
There we go. All right. Thank you. Defense position, Mr. Kennedy.
Well, Judge, I don't see that there's any probable cause for counts 1, 2, and 3. The 923 states that he presented a gun from his waistband, and that's it. Made no threats, nor did they indicate that he made a threat to them or said anything to them in regard to that. And it turned out not even be a firearm.
It was a BB gun. I told him it was a BB gun.
I got nothing more to say, Judge.
Sorry, I'm just really aggravated.
Okay. Mr. Locker, what's your position as to whether there is probable cause for the aggravated assault of a law enforcement officer?
I just think it is reasonable for a police officer who sees what appears to be a weapon and tells the individual to either get away from it or disarm himself, and yet he continues to hold on to the weapon, that there is in fact reason to believe that that he intends to use that weapon, and it's impossible for them to determine that it's a BB gun.
Will you get it back up there?
Somebody listen to me. Well, nobody listened to me. Well, what happened? I'm not talking about the facts of the case. I just told the woman or the men that I had a BB gun and I would be shot.
Just be quiet. Don't say anything to anybody.
See that. I recognize that probable cause sometimes involves making some inferences. Where he is commanded not to reach for his waistband, does so anyway. Rather than placing his hands in the air, he reaches in and withdraws from his waistband this replica gun. Is the circumstances here are indicated that the police officers had a reasonable belief that violence was imminent. Based upon that, that's certainly an argument for trial, and the evidence may not establish it to the requisite evidentiary standard at trial, which is different than what I'm required to use here. Respectfully, I do find probable cause in those matters. Any other argument at this point, Mr. Kennedy?
No, sir. I tried to argue earlier.
It wouldn't have mattered anyway. You guys are going to do what you want to do. I don't give a shit anymore.
Well,
take me back to my cell and feed me so I can take a shit. That's for all I care. You understand? I have no money. I have no life. I have nothing. I don't care anymore. I don't want to hurt anybody. I don't want anything.
On the on-site violation of probation, 5,000 cash or surety. On the violation of probation charge on the warrant issued by Judge McKibben, leave it at no bond as so endorsed. $1,000 cash or surety on the failure to appear in the the misdemeanor case. On the felony burglary charge, leave those as endorsed on the capias. On the condition with respect to that matter, no contact with any alleged victim, don't go to the location of the alleged burglary, in particular, no contact with Walter Belchine or Carmela Belchine. Don't drive any vehicle as you. On the felony case, ending in 340, on each of the aggravated assault of a law enforcement officer with a weapon or firearm, $15,000 cash or surety. On each of the resisting without violence, $500 cash or surety. On each of the fleeing or eluding, $500 cash or surety. I stand corrected. Let me correct that. $500 on the first resisting ROR on the other two, $5,000 on the first fleeing ROR on the other two of those. Don't possess any firearms or ammunition. Any other requested conditions state?
No, Your Honor.
Judge, could you repeat the bonds on the last
Sir,
three counts?
Yes, on the last three counts, $5,000 on the first fleeing eluding ROR on the other two.
Thank you.
Thank you.
Was there
Here for
an
your next
appointment on
court
that
dates. If there was an appointment, I appointed on all the cases.
I didn't hear that.
Appear for your next court date, sir, as reflected in the paperwork, I direct you to sign. Or if not, if permitted by the deputy, if not, I direct that you accept that paperwork. That will conclude your appearance. James Riley.
He's surety bonded, Judge.
Thank you. Avia Cormier. How do you pronounce your name, ma'am?
Avria Cormier.
Avia Cormier. You're here as a result of a warrant issued by a judge in Indian River County. The Indian River County authorities will be notified to pick you up. If they haven't done that by May 31st, it's Friday of this week, right? They'll be brought back before the court here so that other efforts can be made to make sure you're promptly on your way. Yes, ma'am.
I came Wednesday. They said if they haven't came and got me by today, then today's been 3 days.
That's, yes. Hold on for just one moment. Ma'am, when did you get into the Brevard County Jail here?
I got arrested on March 4th for something totally different. Then they dropped my case and gave me 3 days.
Bear with me. When was that case dropped?
The battery and domestic case, I came here on the 22nd, and that's when they told me it was dropped. And they said Indian River had 3 days to come get me from then.
Give me a moment. See, you're right. One thing you said is right, is that they start the clock on this from when your local charges are disposed. So therefore, I'm interested to know when that would be, and I'm looking at that now.
Yeah, they didn't tell me exactly when the case was dropped.
Okay. Huh. They filed a notice of no information on that case on the battery domestic violence on the 21st of this month. There was another case, a traffic case as well. What was that?
Yes, that was the 16th, and I already pled. I made a plea on that already.
That was done on the 17th. I don't know why you weren't brought before the first appearance magistrate on, were you brought before the judge earlier?
For this case, yeah.
Yes.
March 9th. And
March 9th.
yes, but
No, I mean, after your, the disposition of your other case.
yes, it was the 22nd. I guess I should have brought my paperwork.
On the 9th, they just said hold because your local charges were still pending. And then on the 22nd, you were brought before the judge. I'm looking at the minutes here. And they said, remanded set before me for the 28th. So from that point, they expected you to have been transported by the state. I agree. The bond was left at $5,000. I would like to get Lawrence on the phone. Can we go ahead and call him up again, please?
Yes, sir.
What's the number? I'll call.
Want to call from down there?
I'll call from here.
It's going to be 264 5217. I don't know why I can't find it.
Could you?
264 5217.
What? 264.
5217.
You have reached the Brevard County Sheriff's Office Judicial Process Unit. This line may be recorded. Please hold for the first available attendant.
Judicial process, Paul.
Yeah, this is David Silverman. I'm conducting initial appearance proceedings by video at the Brevard County Jail.
Yes, sir.
I wanted to talk to you about a defendant whose name is Avery Cormier, who's been here for about a week on after her local charges were disposed, awaiting transportation to Indian River County.
Okay, hold on just a second, sir, and I'll transfer you to Susie.
Thank you.
This is Susie.
Hi, Ms. Acosta. This is David Silverman again from doing first appearance proceedings. There's a lady by the name of Avery Cormier who's before the court. She's been here for a week in the jail on a waiting pickup from Indian River County, and I'm asked to set this back to this coming Friday. My question is, have we heard from Indian River County? Are they picking her up, or what's happening?
Yeah, well, what happened was on the 22nd, we notified their warrants unit, and apparently they don't handle these type of cases because it's a bond surrender. So jail does, and they weren't notified. But I talked to them this morning, and they're hoping that they'll be able to pick her up tomorrow.
Okay.
We were just requesting the 3 days just in case, but they said that they should be here by tomorrow.
Okay.
They're hoping to anyway.
Very
They
well.
do have another subject that they're picking up too.
Okay. Susie, Ms. Costa, thank you very much.
All right, thanks, Judge.
Right. As you heard, Ms. Cormier, they didn't notify the right people to pick you up. So they've only just gotten notice now of this. The bond will remain at $5,000. You can effect your release by that. I fully expect that you will have been transported there by the next control date, May 31st. If you have not, you'll be brought back before me, and I will make other efforts to either release you or make sure that you're promptly on your way. That's it for now. Sign the paper the clerk will give you. Thank you.
Your Honor.
Thank you. Brittany Gordon? What is your name?
Brittany Gordon.
Gordon, you're alleged to have failed to appear for three different cases. Can you afford to hire an attorney to represent you?
No.
She qualifies.
Appoint the public defender. State, are you agreeable with the amounts as endorsed in the warrants?
Yes, Your Honor.
Defense, any argument at this point?
No, sir.
The bonds as they stand, I would include in those conditions, Kara, the defendant have no contact with the alleged victim, don't go to any place where that person is employed or residing, except for a one-time opportunity to obtain your personal belongings, and then only in the presence of a law enforcement officer. Do you understand?
Yes.
Don't possess any firearms or ammunition, don't consume any alcohol or illegal drugs, obey any injunctions that have issued or that may issue, and appear for your next court dates as reflected on the paperwork I direct you to accept and, if permitted by the deputy, to sign. That will conclude your appearance. Andrea Lunsman. How do you pronounce your last name, ma'am?
Lunsman.
Lunsman. Ms. Lunsman, you're charged with a resisting officer without violence, a misdemeanor kind of charge. Can you afford to hire an attorney to represent you?
No, sir.
Qualifies.
Find probable cause to appoint the public defender, state's position of the bond.
For the on-site, $5,000 for, pardon me, $10,000 for the on-site, and for the new law violation, $500.
The on-site didn't make its way to the docket, did it?
No,
Oh, yes, it did. I'm sorry. I stand corrected. What are you saying? What's your position on the on-site?
10,000.
And on the new charge?
500.
Defense position, Mr. Kennedy.
Judge, I'd ask for the $500 on the new case and $2,500 on the BOP.
Right. She was alleged to have been placed on probation last month, April.
No, it's been 4 months ago.
Oh, I see. One moment, please. Woman. I have a plea agreement that's signed by you with drug conditions stamped into the court file April 4th.
I'm going to steps and all them programs.
Okay. $10,000 is eminently reasonable under the circumstances. $10,000 cash or surety on the on-site, $500 on the new substantive charge.
Substantive charge?
Yes, there's a new charge of resisting an officer without violence.
Oh, I thought
It's
you
not
meant
a violation.
substantive charge. I thought you meant like a
When I
drug
say substantive,
charge.
I mean it's not, more accurately, it's a new charge that's not a violation of probation charge.
No, I thought it was a drug charge. Or it was, I'm sorry.
No, that's, okay. On the violation of probation, adding conditions, don't possess or consume any illegal drugs, and appear for your next court dates on those two cases, ma'am, as reflected in the paperwork I direct you to sign. Thank you. That brings us to Eric Bowerman.
And Your Honor, Mr. Bowerman intends to either hire counsel or represent himself.
Very well. Mr. Bowerman.
Sir.
You're charged with false imprisonment and a assault alleged to be a domestic violence type incident. I'm given to understand that you desire to hire an attorney or represent yourself. Is that so?
That is correct, sir. If this has to go further, any farther in this court, then I will probably hire a private.
Sorry, I couldn't quite hear you. Is that microphone on?
I think I said yes, sir. If this goes any farther than this court proceeding, I will probably hire an attorney.
Okay.
I also want to mark that.
But if it later on, if it turns out that you're unable to hire counsel, you can apply for the appointment of counsel to your trial court judge. Do you understand?
Yes, sir.
Find probable cause. State, what's your position on the bond?
Your Honor, the state has been contacted by the victim in this case, and indicates that she's afraid of the defendant, and he's threatened her in the past and her animals. She's requesting no contact and no return, of course. The state is also requesting a ankle monitor, and the state is requesting us for bonds, $15,000 for count one and $1,000 for count two. And again, no contact and no return, and
Can I make a statement?
ankle
Sure,
monitor.
She's my wife. By the way, we got married April 24th. She's not my girlfriend, so it's misappropriate. They quoted her as my girlfriend. She's my wife. We've been married since April 24th of this month, last month of May. Wait, April.
Right. Sir, I would ask that you not talk about the case, but if you have anything about your background or community ties that would help me make a fair decision on the bond, you're representing yourself at this point. You're entitled to do so. Are you employed, sir?
No, sir. I'm on SSD, sir. Social Security Disability.
Okay. Do you own any land or house?
Yes, I own the house, but it's under a trust. It's under a trust, sir. And I have 2 cars and a trailer.
How long have you lived in Brevard County?
Over 20 years, sir.
Okay. All right. If I direct you not to have contact with Mila Daniels while this case is pending, will you comply with that instruction?
Yes, sir.
Very well, even if it means you need to find some other place to live.
Yes, sir. You know, it's my house, yes, sir.
All right, very well. 15,000 cash surety count one. Wait just a moment, please. I may have misspoken. She's alleged in this case to have been kept captive in the residence. Is that your understanding, Mr. Loughran?
That is correct, Your Honor.
But could go to work, apparently. Satisfied with 15,000 on count one, state? Ms. Loughran,
Yeah, I'm sorry, Your Honor.
are you satisfied with 15,000 on count one?
I would be satisfied if there was an ankle monitor. That's my,
Yes, sir. Very well. 15,000 cash surety count one, 1,000 cash surety count two. Conditions. No contact with Mila Daniels. Don't go to any place she's residing except for a one-time opportunity to obtain your personal belongings and then only in the presence of a law enforcement officer. Do you understand?
Yes, sir.
Don't possess any firearms or ammunition. Don't consume any alcohol or illegal drugs. Obey any injunctions that have issued or that may issue. Do we have that so far, Kara?
Yes, sir.
Now then, before you are released from the Brevard County Jail, I direct that an ankle monitor, an ankle GPS monitor be installed on your person and activated, and that it be calibrated to preclude the defendant from going to any place of where Mila Daniels is employed or where she resides. He is not to be released unless and until that is in place, and I direct that he maintain that in place until further order of the court. Is that sufficient at this point from your perspective, Mr. Loughran?
it is, Your Honor.
All right, appear for your next court date, sir, June 25th, before Judge Brown, as reflected on the paperwork I direct you to sign.
Your Honor, are you including a radius to keep away from the residence or employment, or just?
I couldn't quite hear you, ma'am.
Are you including a radius to keep away from the house and employment, or just no return?
I would like a radius. It should alert at 100 feet.
Thank you.
Thank you. Kwame Brown.
Kwame Brown, sir.
How do you pronounce your first name?
Kwame, sir.
Sir? Kwame Brown. Ms. Brown, you're here as a result of a charge of resisting an officer without violence. Can you afford to hire an attorney to represent you?
No, sir. I'll be honest with you, sir. I was trying to harm myself last night and take my life.
My question, why don't you hold off on that, please?
Yes, sir.
I promise I'll hear you if that's appropriate in just a moment.
Yes, sir.
But I would like to announce on the record that I do find probable cause and appoint the public defender. State, what's your position on the bond?
The state would agree to an ROR as long as he is released to circles of care or another facility for his mental health issues.
Will they pick him up from circles of care if we do that?
My understanding, they will.
All right. What do you say, Mr. Kennedy?
Total agreement with that, Judge.
All right. Sir, I want to ask you, Mr. Brown, if they come from Circles of Care is a local mental health facility, okay?
I know.
If they come and pick you up, will you give them any trouble?
No, sir. Because
All
really,
right.
that's all I was really crying for last night, help.
Judge, just for the court's information, I spoke to him before court, and he wanted to go to Circles of Care.
All right, very well.
He knows he needs.
We'll release the ROR on the condition that he be released only to Circles of Care, not released to go there, but only released to that facility, provided that they pick him up. Okay, that'll do it for now. Appear for your next court date, sir. I have a question. One more question. Do you plan on doing any harm to yourself?
To be honest with you, I've been going through a lot. Last night was a breaking point, but I'm not going to sit here and tell you that I'm not, and I'm not going to sit here and tell you that I am.
All right. Well, okay. Look, a couple points. One, I'm directing you not to do that, and put that in the minutes. Not to commit or attempt to commit any suicide or other harm to himself. But also, this is a misdemeanor case. Okay, on the overall spectrum of things, this is toward the shallow end. Okay? So this should not push you over the edge in this matter. I want you to get some help on this and try and get yourself better, okay?
Yes, sir, but the case is not the reason why I tried to harm myself. It's because
I
my
understand,
mother is
but
dying from
sometimes-
stage 4 cancer.
I'm sorry for what you're going through. But what I wanted to convey was that sometimes there's one thing that pushes you over the edge. This shouldn't be it, because this is just a misdemeanor charge, right? Okay. Go ahead now. That'll do it for today. Thank you.
Thank you.
Okay. Robert Cornell. What is your name?
Robert Cornell.
Mr. Cornell, you're charged with possession of synthetic cannabinoids, possession of cannabis oil, possession of drug paraphernalia, and possession and resisting officer without violence. Can you afford to hire an attorney to represent you?
Not from in here.
He's actually non-indigent by $20 a week.
Okay. What do you do for a living, sir?
I'm a pipe layer.
Okay. What are you paid to do that?
About $600 a week.
$600 a week? Do you support anyone other than yourself?
No.
Is that 600 gross, or is that after taxes?
That's after taxes.
It's after taxes. You wouldn't qualify at 600 a week.
He
Look,
indicated
I'm
500 a week, so if he's now
Okay,
stating
okay,
it's
well-
600, it's more.
All right. Well, based on what I have before me at this point, I don't find that you qualify under the guidelines that I'm required to use for the appointment of counsel. However, let's say you try and hire an attorney and you're unable to do that, you can place a request to your trial court judge, say, look, I tried to hire a lawyer, here are their cards, I tried to talk to these guys, I can't hire, I don't have the financial ability to do it. The judge can then consider appointing counsel to represent you there, but I'm not doing it here. State, what's your position on the bonds?
2,000 for count 1, 2,000 for count 2, 500s for count 3 and 4 each.
Okay. That would be the downward departure on 2, wouldn't it?
I don't know where they got 5,000. It's a second-degree felony that's nonviolent.
It's a third-degree felony, isn't it?
That's what I meant. I meant third degree. I don't know where they came up with 5,000.
I don't know. They must be characterizing it as some other variety of hashish or something. I'm not sure. Moment, please. Okay, sir. How long have you lived in Brevard County, sir? Mr. Cornell?
About 25 years.
Okay. Okay. Drive stunned is tased, right? He was drive stunned twice. Okay. So I think that that's reasonable in accordance with the schedule, 2,000 on each of the felony counts, 500 on each of the misdemeanors. Don't possess any illegal drugs or illegal drug paraphernalia. Do you understand?
Yes, sir.
All right. Appear for your next court date is reflected in the paperwork I direct you to accept, and if permitted by the deputy to sign. Bobby Jesiorski. What's your name?
Bobby Jezorski.
Jezorski?
Yes, sir.
You're charged with aggravated assault and aggravated assault with a deadly weapon and criminal mischief. Can you afford to hire a lawyer to represent you?
No.
He qualifies.
Find probable cause. Appoint the public defender. State's position of the bond.
The state is going to request a no bond on count 1, 5,000 for count 2, and 500 for count 3. The statements that he made to the police regard how he's going to handle when he's released from jail and someone won't see the daylight anymore when he gets out causes great pause for the state that he, in fact, is intending to
under aggravation
to do harm. That is.
Do you agree that when he was making some other epithets with the what he purported was a 9mm turned out to be a BB gun, right?
Correct. Unfortunately, or fortunately, it was a BB gun. But when he pulls a trigger, and there's, and his history is such that there is violence in the history as well. So this state has severe concerns. If the court was not interested in no bond, bless you, the state would request a $50,000 for count 1, $15,000 for count 2, and 500 for count 3.
All right, defense possession.
Judge, I'd ask the court to consider no more than 5,000, count 1, 5,000, count 2, and 500, count 3.
Give me a moment. State reports have a strong case. They've got 3 witnesses in video, according to what they have here. Yeah. The I recognize your point, Ms. Loughran. Someone won't see daylight anymore when he gets out. There's this not directed at the officer in particular, at the officers who are arresting him, or necessarily Mr. Watson, and is susceptible to interpretation to the effect that somebody else is going to jail, because I'm innocent, and you're all going to be in trouble.
The state
So
is
I
also
recognize that.
the state is also concerned about the fact that, and this may seem like a minor issue, but the state does not see it that way, and that is BB guns all have a red, yellow, or some kind of a thing around the barrel, or around the tip of the barrel. And when you remove them, you're doing so in order to indicate to that it is in fact a firearm. Clearly, the defendant had fully intended to frighten somebody with the use of that, and it all becomes, as far as creates a very scary circumstance for the state.
Well, we start out in this with the dispute between the neighbors, in which he's you said that he was battered by the neighbor. He's alleged to have thrown a rock at the neighbor but missed. So that was not resolving things. He threw a rock at the trailer, caused an estimated $150 worth of damage, and then pulled from his pocket the firearm, what purported to be the firearm, making some extravagant threat to suggest that it was something more than what it was. No, I take the point, Mr. Loughran. This was a deliberate attempt to scare him, to frighten him when there were other their controversy wasn't being otherwise resolved. But I think that factoring that in, I think that 50,000 is reasonable, and being that it's I think that had this been a firearm, I very well might view this differently, but being that I think he's entitled to a monetary bond. 50,000 cash or surety on the aggravated assault. Make it 5,000 on the aggravated assault with deadly weapon. Actually make it 5,000 on the aggravated assault, and 1,000 on the criminal mischief. I think it's a little more serious when you're throwing it into throwing against the trailer and breaking it, as it could be potentially injurious to somebody inside. Conditions: no contact with Travis Watson. Do you understand?
Yes, sir.
Don't possess any firearms or any replica firearms or any ammunition or any BBs. Do you understand?
Yep.
No BB gun. Do you understand?
Yes, sir.
All right. Any other requested conditions, State?
Certainly no contact and no return, Your Honor. If that wasn't
Well,
mentioned, I
then don't-
apologize.
No, I did have that. All right, if Travis Watson was residing at that same residence, you can't go back there. Do you understand?
We're neighbors next to each other.
Okay. It's your lookout to not have contact with him. Do you understand?
Yes, sir.
All right. Appear for your next court date, June 27th, as reflected in the paperwork I direct you to sign. Thank you. Blake Montagna.
Yes, Your Honor.
Hello, Mr. Montagna. You were carried over for the last couple of days, being in medical, I believe.
Yes, Your Honor.
A moment, please. Here as a result of a charge of robbery and one of resisting an officer without violence, can you afford to hire an attorney to represent you?
No, Your Honor.
Qualifies.
Find probable cause and appoint the public defender. State's position on the bond.
5,000 for count one, 1,000 for count two.
Defense position.
No objection to the schedule.
But 5,000, 5,000, you want 5,000 and 1,000, is that correct?
That's what I'm requesting.
Right.
Yes, Your Honor.
All right, Mr. Montagna, 5,000 cash or surety count one, 1,000 cash surety count two. No contact with Tammy Bright and no contact with Jason Vargas. Do you understand?
Yes, Your Honor.
Don't possess any firearms or ammunition. Don't consume any alcohol or illegal drugs. Appear for your next court date on June 25th. As reflected in the paperwork, I direct you to accept and if permitted by the deputy to sign.
Yes, Your Honor. What's today's date? How long?
Today's date is the 28th
June 25th.
of May, 28th of May, 2019. It's continuing on. Thomas Rodifer.
Yes, sir.
What is your name, sir?
Thomas Rodifer.
Mr. Rodifer, there's 2 counts of battery on a emergency medical care provider. Can you afford to hire an attorney to represent you?
No, sir.
He qualifies.
Find probable cause, appoint the public defender, state's position on the bonds.
Yes, Your Honor. In just 1 second. The state is requesting 8,000 for count one and 8,000 for count two. Actually, I'm correct that that's 10,000 for count one and 10,000 for count two. His residence appears to be Brunswick, Georgia.
Defense position.
Well, Judge, despite his residency out of state, he's got 1 prior misdemeanor back in 2001. I'd ask for a bond of $2,500 per count.
he was, according to the arrest report, he was aggressive and used his head as a weapon with respect to, there was one who was a male and a female there at Holmes Regional Medical Center. And after the second time, as they were trying to hold him down, he said, yeah, try that, get some more. 10,000 is eminently reasonable in this case, but for that being the bond schedule and the state's recommendation, my bond might well be higher. 10,000 cash or surety on each of the counts. Don't go to the Holmes Regional Medical Center. No contact with any alleged victim. Don't possess any firearms or ammunition. Appear for your next court date, Mr. Rodifer, on June 25th, as reflected in the paperwork I direct you to sign. Please, to Carlos Aponte.
Hello, Your Honor.
What is your name?
Carlos Aponte, sir.
All right, Mr. Ponte, you're charged with 3 counts of driving under the influence with property damage, and 1 count of driving under the influence with above .15. Can you afford to hire an attorney to represent you?
No, Your Honor.
Find probable cause of public defender state's position on the bond.
Excuse me, sir.
Sir, let the state speak.
The state is, the 923 does not seem to indicate the damage. It seems to be void of that. The state is a little concerned about that. It mentions it
Well, let's inquire. What's your position with respect to whether if you agree that there's not probable cause, should we set this to another date?
No.
To permit you to do that? No.
No, I would say ROR for count 1 and 1,000 for count 2.
Excuse me, Your Honor.
But there's actually 3 counts of driving under the influence with property damage, and there's only one. There's 1 count of the DUI above .15. So, how does that?
Well, again,
what's your position?
I just don't think that there's PC for any one of the 3, and the fact that they're misdemeanors, I'm not. They can deal with that in trial court, but the state believes 1,000 is appropriate for count 4.
Well, let me ask you a question, Mr. Loughran. Sometimes in county court, we use the citation as a charging instrument. I recognize it's not sworn, but if you look at the citation, it indicates on it that there's $18,000 worth of damages estimated by the officer, right?
That's correct.
Is that something that the court can use or not with respect to probable cause on whether there was property damage?
Yes, I do think so.
All right. So are you agreeable with the schedule on these?
Yes, Your Honor.
All right. Defense position.
No objection to the schedule.
All right. Mr. Ponte, I'm going to leave the bonds as they stand. Appear for your next court date on June 25th, and don't consume any alcohol or illegal drugs.
Your Honor.
Don't drive a motor vehicle.
May I speak?
Don't drive a motor vehicle without a valid driver's license. They may have suspended your license on the DUI arrest here.
Yes, sir. I'm a single parent raising 3 kids by myself, and right now I have no family here, and I've been here in Orlando for 23 years, and I have my 18-year-old that he's mentally ill, and I have a 12-year-old and a 17-year-old and an 18-year-old, and they home by themselves right now, sir. I have no money, and I need to make it back to Orlando. You can trust in me on ROR. I have no one to bond me out of here, sir.
That makes it very important for you to contact your attorney. Kara?
Yes, sir.
Kara?
Yes.
Could you write on his paperwork the following telephone number, 321-617-7373, and write under that public defender. You should go ahead and call them immediately upon your getting this paperwork, and that will conclude your appearance here today. Sign that and appear on June 25th, as I have indicated.
Thank you.
That brings us to, thank you, brings us to Brian Batchelor.
Surety bond, Your Honor.
Very well. Jonathan Bloomquist. What is your name?
Jonathan James Bloomquist.
Ms. Bloomquist, you're charged with trespass and resisting officer without violence. Can you afford to hire an attorney to represent you?
No.
He qualifies.
Find probable cause and appoint the public defender, state's position on the bond.
500 for each count, Your Honor.
Okay. Defense position.
No objection to schedule as it appears on the docket.
No. Right. One moment. There's a fairly healthy prior history. You state, but I do recognize he's alleged to have resisted the officer by repeatedly throwing himself down on the ground, right?
Correct.
Say that agreeable with just the amounts as endorsed on the arrest report from the schedule.
Yes, Your Honor, I am satisfied with that.
All right. 500 cash or surety on each of the counts. Condition, don't go to the Cocoa Beach Pier. Do you understand?
Yeah.
Okay. Appear for your next court date, sir, on June 17th as reflected in the paperwork I direct you to sign. Brings us to Robert Farley. What is your name?
Robert Farley.
Ms. Farley, you're charged with a violation of probation, but also contempt by failing to serve the farm time that you were ordered to do. Can you afford to hire a lawyer to represent you in this matter?
No, sir.
He qualifies.
Appoint the public defender. State, are you agreeable with the terms as set forth on the warrants?
Yes, Your Honor.
All right. Any argument at this point, Ms. Kennedy?
No, sir.
All right. 1,000 on the contempt, 1,000 on the violation of probation. On the contempt warrant, he is to be ROR'd if he is not bonded out at the end of 10 days. And on the probation warrant, he's to report to probation within 48 hours upon release. Appear for your next court date in any event on June 26th before Judge Friedland, as reflected on the paperwork I direct you to sign.
Sorry, sir.
Cecil Francis. What is your name?
Cecil Francis.
Francis, you've got, there's 3 charges of solicitation to sell heroin, three charges of conspiracy to possess heroin, and 3 charges of unlawful use of a communications device. Can you afford to hire an attorney to represent you on this matter?
No, sir.
He qualifies.
Find probable cause from the affidavit and appoint the public defender. State's position on the bonds.
The warrant amount, Your Honor.
Defense position.
The warrant, Judge.
Very well. Leave the bonds as they stand as endorsed in the warrant. Don't possess any illegal drugs. Appear for your next court date on June 25th as reflected in the paperwork I direct you to accept and if permitted by the deputy to sign.
Yes, sir.
Brings us to Aaron Gaddy. What is your name?
Aaron Gaddy.
Gaddy, you're charged with possession of a controlled substance, driving while license suspended, possession of drug paraphernalia, and tampering with physical evidence. Can you afford to hire an attorney to represent you?
No, sir.
Qualified.
A moment. Find probable cause. Appoint public defender, state's position on the bonds.
The bond schedule, Your Honor.
Defense position.
No objection to the schedule, Judge.
All right, leave the bonds as they stand. Don't possess any illegal drugs or illegal drug paraphernalia. Don't drive a motor vehicle with a valid license. Do you understand?
Yes, sir.
Okay, appear for your next court date, June 25th, as reflected in the paperwork I direct you to sign. Eric Garton. What is your name, sir?
Eric Garden.
Mr. Garton, you're charged with resisting an officer without violence and possession of drug paraphernalia, and then there's a violation of probation charge. Can you afford to hire an attorney to represent you?
No, sir.
Qualifies.
Find probable cause on the new charges on the on-site. Appoint the public defender, state's position on the bond.
As to the new case, 500 for each count. As to the on-site, 5,000.
Defense position.
Judge, I agree with the state's recommendation on the new case of 5,000 per count, and I'd ask for no more than 2,000 on the.
500. Okay. It was. Okay, you was placed on probation earlier this month, right? On this? But for the state's recommendation of 5,000, I might expect my bond might be higher on the violation on the on-site. On the on-site violation, probation 5,000 cash or surety, make it 1,000 on each of the misdemeanors. Don't possess any illegal drugs or illegal drug paraphernalia. Appear for the next court dates as reflected in the paperwork I direct you to sign. Brings us to Christopher Gorman. What is your name?
My name is Christopher Gorman, sir.
Mr. Gorman, you're charged with aggravated assault with a deadly weapon. Can you afford to hire an attorney to represent you, Mr. Gordon?
No, sir.
Gorman.
Qualifies.
All right, find probable cause and appoint the public defender, state's position on the bond in Mr. Gorman's case.
The state is requesting 10,000, Your Honor.
Defense position.
I'd ask for a bond of no more than 5,000.
He was convicted last year of battery, domestic violence. Was this the same alleged victim?
I can't tell.
Yes, sir.
Oh, yes, I can.
State still satisfied with 10?
Now that he's confirmed that 15 would be more appropriate, Your Honor.
What do you say, Mr. Kennedy? Says in a heated altercation, displays a knife, says, "I am going to kill you," as a showing the knife in her direction. Anything else, Mr. Kennedy?
No, sir.
I agree, 15,000 is reasonable, and there's 15,000 cash surety conditions. No contact with the alleged victim. Don't go to any place she is residing except for a one-time opportunity to obtain your personal belongings, and then only in the presence of a law enforcement officer. Do you understand?
Yes, sir.
Don't possess any firearms or ammunition. Don't consume any alcohol or illegal drugs. Obey any injunctions that have issued or that may issue. And for the record, it's Santora Butler. No contact with her. Do you understand?
Yes, sir.
Appear for your next court date, June 25th, is reflected in the paperwork I direct you to sign. Thank you. I do mean to direct those questions more particularly to the state. Try and be careful.
Judge, if Mr. Hawes would qualify as conflict.
Mr. Hawes, thank you. State alleges in your case a charge of driving under the influence, possession of cannabis, and 6 counts of contributing to the delinquency or dependency of a minor. Can you afford to hire an attorney to represent you?
No, Your Honor.
Go ahead and pass on Hawes for the moment. I'd like to give conflict counsel a call. I appoint legal conflict counsel representative, and we'll take that up in just a moment. Okay? Thank you. Next we have is William Mashburn.
Yes, sir, Your Honor.
Okay. Are you William Mashburn?
Yes, I am, sir.
All right. These two there was a on-site violation of probation and possession of cocaine that were held over for a probable cause hearing today. Is that correct?
Yes, I believe it's held over. They couldn't find a probable cause.
That's more accurately directed to the prosecutor. Is that your understanding, Mr. Lochran?
Just give me one moment, Your Honor. Yes, I have notes here. I just want to check to make sure I'm correct. Yeah, my understanding is that the court had raised a potential issue of probable cause because the agency report did not indicate that Mr. Ashburn was the sole driver, I don't have anything further from the Palm Bay Police Department as to the circumstances, but the state would point out that I don't believe that would really be a prohibition, because constructive possession would be just as appropriate, and also the 923 indicates that the drugs were found between the console and the driver's seat. So the state believes that there is PC.
All right, give me a moment. Judge Garagazzo saw him yesterday.
That was Garagazzo. I'm sorry.
And
I would also point out that he's on probation, and as a result, he's not supposed to have any illegal drugs anywhere near him.
It wasn't mine. I didn't know it was there.
There you go.
okay. Look, an orange container between the center console and the driver's seat. That container, a white rock-like substance confirmed to be crack cocaine. But let me ask you, let me tell you where I'm at on this. This was within ready reach of him. He was in the driver's seat. It's immediately to his right, between the console and the seat. So, might take it would be that there's probable cause. Judge Garagazzo found that there was not. No, there's no news showing by the state. I'm unclear as to whether I can just go ahead and review that at this point and find probable cause.
I don't believe that a pair of fresh eyes is prohibited in finding the PC.
What do you say, Mr. Kennedy?
Judge, I'm still trying to figure out why it was held over.
This is stronger than a number of the cases we see because this would have been, I mean, there's always, the fact that Mr. Mashburn has an innocent hypothesis of this doesn't preclude the existence of probable cause. This is not proof beyond and to the exclusion of a reasonable doubt, but this lesser standard I am required to use here. Respectfully, I find probable cause in this matter. We would appropriately address the bonds. State, what's your position on the bonds?
As to the possession of the crack cocaine, $2,000. As to the on-site, the state is requesting $10,000.
Defense position, Mr. Kennedy.
Judge, on the new case, I'd ask for bond no more than the schedule of $2,000, no more than $5,000 on the VOP.
Okay. All right. My impression is that he was placed on probation 6 days ago, right?
That's correct.
And that he's had about a half dozen different incarcerations in a state prison facility. Is that so?
That is correct, Your Honor.
And a healthy record consistent with that. When I say healthy, I mean substantial prior criminal history. States he's also got 5 failures to appear, or at least 5 convictions for them. State you're agreeable with $10,000 on the onsite?
Yeah, I am, Your Honor.
And your thinking in part is that if and when they issue a warrant on this, that will override this in any event. Is that so?
That's absolutely correct. It's going to be no bond, I'm sure.
Had at least 3 sales of cocaine convictions. 5,000 cash surety on the possession of cocaine, 10,000 on the on-site. Conditions: don't possess any illegal drugs. Appear for your next court dates, sir, as reflected in the paperwork I direct you to sign.
Thank you.
Thank you. Aaron Miller. What's your name?
Good morning. I'm Aaron Miller.
Well, Mr. Miller, you're charged with trespass and resisting an officer without violence. Can you afford to hire a lawyer to represent you?
No, Your Honor.
Appoint the public defender, find probable cause, state's position on the bond.
$500 for each count, Your Honor.
Defense position.
No objection to schedule.
All right. Leave the bonds as they stand. Conditions. So are you employed?
Yes, sir. That's what I was a little worried about being in there for 3 weeks to get to a court
What do you
date.
do for a living?
I do
What do you do?
plastering and masonry work.
Right. No contact with Anne Marie Harris. Don't go to the address at 4341 Eleanor Drive in Melbourne. Do you understand?
Yes.
All right. Appear for your next court date on June 17th is reflected on the paperwork I directed you to sign. Adam Neve.
Your Honor, if Mr. Neve would qualify as conflict.
Thank you.
What is your name?
Adam Neve.
Ms. Neve, you're charged with possession of a controlled substance and possession of drug paraphernalia. Can you afford to hire a lawyer?
No, sir.
Right. Appoint regional conflict counsel. Let's go ahead and give them a call in just a moment. I'd have you take a seat back to permit me to do that. There may be some other folks I'd like to address with them at that time. Thank you. Ronald Nichols. What's your name?
Ronald Nichols.
You're charged with resisting an officer without violence and possession of drug paraphernalia. Can you afford to hire a lawyer?
No, sir.
Qualified.
Find probable cause, appoint public defender, state's position on the bond.
500 for each count, Your Honor. No alcohol or no return to the location, pardon me, no alcohol and no illegal drugs.
No objection, Judge.
All right. State satisfied with the amounts that they stand. In light, there's some criminal history and some disrespectful activity or conversation by the defendant. Still satisfied with the schedule?
Yeah, yes, I am, Your Honor.
All right. 500 cash or surety. Don't possess any illegal drugs or illegal drug paraphernalia. Do you understand?
Yes, sir.
Yes. Appear for your next court date, June 24th, is reflected in the paperwork I directed you to sign. Let's go ahead and Eric Novak.
Good afternoon, Your Honor.
Good afternoon, Mr. Novak. You're charged with battery as alleged to be a domestic violence type incident and also a charge of violation of probation based upon that. Can you afford to hire an attorney to represent you?
Not right this present time, no, sir.
He's non-indigent, Your Honor, by $220 a week.
I just
What do you
started.
do for a living, sir?
I started a new job last week, and that's
What
the
did
money
you
I
do?
put in. I put in 50 hours. That's the reason I put that amount down. I
What
am.
do you do for a living?
I am building the new terminal, cruise terminal at the Port Canaveral. Construction.
You're building it. Are you a contractor?
No, sir.
I work for Ivy's Construction.
What do you do for them?
I am a supervisor as far as construction.
Are you a foreman on the
Foreman,
job?
yes, sir. No, I'm not a foreman, no, sir. I'm just I run a crew
Say
like
supervisor, what do you mean?
I run a crew of 3 or 4 gentlemen, just forming up for the concrete slab.
Okay. I don't find there are guidelines based on the federal poverty guidelines that I'm required to use in appointing at this point. If it turns out that you're later unable to hire, as you lack the financial ability to hire a lawyer, you can apply for the appointment of counsel to your trial court judge. I find probable cause. What's your position on the bond?
As to the DV battery, the state is requesting 500. As to the probation violation, the state is requesting 5,000.
All right. You can tell me if you want to about your background and community ties if you'd like. I'd ask you not to talk about the case.
Okay,
So,
yes,
for
sir.
example, how long have you lived in this area? How long have you lived in?
I have lived in this area for 35 years. I graduated Satellite High School, 1982.
Aside from Catherine Dole, do you have any family members here?
Yes, sir, I do. My mother.
Who would that be?
She lives in Merritt Island, Florida. She's going to pick, that's who I'm going to stay with. My father just is deceased as of 3 months ago, so she really needs my help at this point. Also, anyway, so.
What do you recommend on the on-site stay?
5,000, Your Honor.
$500 on the new charge, right?
That is correct.
That seems to me to be a makeable bond by you. That's the total of $600 to a bondsman.
Yeah, I'm not exact certain if I still have my job. I really don't know at this point. I haven't had a chance to talk to my boss or anything yet. I've been here 2 days, and I really don't know if I still have my job. I was only there for 5-6 days. I'm pretty much believing that I don't have my job with them anymore, but I'm praying I do.
Well, if the employer believes that you will do a good job for them, they may very well be willing to keep you on.
Yes, sir.
I mean, I think the ultimate decision is for your employer. It's a business decision for them to make.
Yes, sir.
5,000 is reasonable on the on-site violation of probation. That's a felony type charge.
Yes, sir.
And the 500 is reasonable on the misdemeanor. No contact with Catherine Dole. Don't go to any place she's residing except for a one-time opportunity to obtain your personal belongings, and then only in the presence of a law enforcement officer. Don't possess any firearms or ammunition. Don't consume any alcohol or illegal drugs. Obey any injunctions that have issued or that may issue. Be sure and be in good contact. If you can't post that bond, be in contact with a lawyer to get your case placed before the trial court judge right away. Okay?
Yes, sir.
Your current sign the paperwork clerk will give you with your next court dates. Coincidentally, they're both on June 17th.
Thank you, Your Honor.
Thank you. Brings us to Dawson Payne. What is your name?
Dawson Payne.
Ms. Payne, you're charged with battery, domestic violence type battery that's alleged to be a felony type charge, fleeing or eluding an officer, driving while license suspended, criminal mischief, and giving a false name to a law enforcement officer. Can you afford to hire an attorney to represent you in this matter?
No, sir.
I'd like another moment, please. All right, find probable cause, state's position, and appoint the public defender, state's position of the bond.
5,000 for count one, 5,000 for count two, and 500 for each of the three misdemeanors.
Defense position.
No objection to the schedule requested by the state.
All right. 5,000 cash or surety count one, 5,000 cash or surety count two, 500 on each of the remaining misdemeanors. Conditions. No contact with Mia Harrelson. Don't go to any place she is residing except for a one-time opportunity to obtain your personal belongings and then only in the presence of a law enforcement officer. Do you understand?
Yes, sir.
Don't possess any firearms or ammunition. Don't consume any alcohol or illegal drugs. Obey any injunctions that have issued that may issue. Don't drive a motor vehicle without a valid driver's license, and don't possess any identification that is not your own. Appear for your next court date, June 27th, as reflected in the paperwork I direct you to sign. Michael Tiberio.
Good afternoon, Your Honor.
Good afternoon, Mr. Tiberio. Didn't I see you just a couple days ago?
Yes, sir, and you put me on hold till today.
Okay. Oh, here's the situation on this. Correct me if I'm wrong. He was it was unclear whether he was on probation.
He's on probation.
I am on probation.
Okay. He's on probation. It's not, there's no on-site violation of probation.
Not yet.
He is, there's a petty theft charge, and according to the state, it was represented by Mr. Guzmano last week. He would be AMA. So the question is, should he be held pursuant to the Anti-Murder Act on this matter?
Yes. The state, first of all, the state is requesting an onsite, for the court to onsite him. He is currently on probation. He has violated probation. There was independently, there was a notice to appear prior to this, so that would toll any possibility of the termination, although he wouldn't terminate until mid-June of this year. But the fact is that he, even notwithstanding the fact that there was a capias, that still does not, the capias was issued, or was a crime that was issued during the term of his probation. As a result, because of his history, it's based upon an armed robbery with a deadly weapon out of Maryland in '95, and that's the qualifying offense. And the state is requesting that he be held, that he be found AMA, and that the court find.
See, one of the things that tended to impress me, Mr. Loughran, was that Judge Lemonitis had, with his history, rather than violating him on the, or issuing a warrant to do so, that she just gave him a notice to appear on the monetary obligations he hadn't fulfilled.
Yeah, I think you're reading more into that. I mean, I read Mr. Cusmano's notes, and I'm not sure. There are many times that I have seen, and that come through here, where a judge, even though a person may be on probation for a qualifying offense, still issue a bond amount, $7,000, $10,000, whatever it may be. So I'm not sure that she may have been cognizant of that at the time that she did so, and notwithstanding that fact, he fulfills all of the requirements for being held AMA.
Only authorized to on-site him from this point, where that was not alleged by the officer.
Yeah, you have certainly got the authority.
However, Judge.
Mr. What's your position on that matter?
Well, Judge, he's charged here with a petty theft misdemeanor, He's on probation for a driving offense of felony driving while license suspended. I'd ask the court not to violate him at this point with an on-site, allow the trial court to address that matter. I see that an AMA is coming no matter what, but I'd ask the court to allow the trial court to address that issue, considering the nature of the offices here. I mean, it may come tomorrow, but it's, you know.
See,
it still
Ms.
has to-
Lochran, I tended to view it differently, that my perspective on this is that Judge Lemonitis would have had, would have been in a superior position to me to have evaluated that, and she didn't buy them, but only sought to have notice to appear on these remaining, the things he hadn't fulfilled. So it wasn't, that was my thinking.
Well, I understand that. And with all due respect to the comments made by counsel and also by the court and also your determination of what Judge Lemonitis did or didn't do, it's not up to her to decide whether or not it will or won't. It is you are or you are not. It is not an optional choice. If a person is on probation, on felony probation, and they have a qualifying offense, then they are AMA. It is not discretionary. It's that simple.
I have not
Mr.
been.
Lochran, Judge Lemonitis avoided that by not violating him and simply just by doing the notice to appear, right?
I have not.
I don't think, like I said, I don't think that is in her power to void anything. The statute is clear.
I didn't say void, I said avoid.
Well, avoid, either way, the point is, you can't, that's why I would think that knowing Judge Lemonitis, I would be shocked to think that she would avoid it. But notwithstanding that, it doesn't matter. The fact is, it is what it is. AMA is AMA. There's no discretion in metering AMA out. It is a statute, and we're expected to follow the statute. And I'm requesting that you on-site him, and I'm requesting that it be held AMA.
And Judge, I agree. The state is right. It is inevitable. However, my argument is to ask this court to allow the trial court to address the on-site, because that is discretionary on this court whether to issue an on-site or not. And I'd ask the court to allow the trial court to address it.
Well, the issue, I don't know. Yeah, the issue is that apparently Judge Lemonitis is on vacation this week, which is hence bringing it back to before you, Your Honor.
You know, I too fully expect that Judge Lemonitis is conversant with the requirements of the AMA. And so therefore, I was interested to learn what her perspective on this was, because I agree with the proposition. It is it leaves the court with no discretion on this matter. Now, I understand that there's some argument to be made. I wouldn't on-site him, but on this matter, I would go ahead, issue an on-site violation of probation in 18 CF 21941-A. No bond on that. Is he entitled to a bond on the petty theft, Mr. Lochran?
Yes, Your Honor.
What do you recommend?
The state would recommend $500.
Any argument as to the misdemeanor?
No, Your Honor.
500 cash or surety. Don't go to the location of the alleged offense. No contact with the alleged victim. Appear for your next court date. As reflected in the paperwork, I direct you sign.
Okay, so
thank you,
Your Honor.
So do I?
Before, pardon me, I'm just, I think you may have misspoken. As to the case numbers, I see it as 18-21741 CFA.
I'm sorry, I may have 21741. I misspoke as to the number.
I can't hear him when you're talking.
Robert Wilhide.
Judge, did you issue? I can't hear you over here sometimes. What did you do about the VOP? Did you issue an on-site?
The VOP, I issued an on-site on that matter and directed he be held with no bond pursuant to the terms of the Anti-Murder Act.
Thank you.
How can I have that when I haven't actually violated yet?
This is a violation.
Huh?
Okay. Well, the
I haven't even been
The state
questioned for it
confirmed
yet.
that the probation was ongoing. There's a new criminal offense for which I have found probable cause. Therefore, that would constitute a violation, and I direct that you be held pursuant to that violation as I have just ordered. Now, Robert Wilhide.
Y'all are.
What is your name?
Robert Wilhide.
So you're alleged to have failed to appear for proceedings in a misdemeanor case. Can you afford to hire an attorney?
No, sir.
Appoint the public defender. Any argument as to the bond?
No, Your Honor.
Just give me a moment. All right, let me tell you, here's my concern. If he's left here on this panhandling charge, they may not, because he's already a failure to appear, he would be in here until the date in July when he sit before Judge Ingram. I'm inclined to an ROR after a particular number of days on this as a result. That's what I'm thinking. Because I think $500 to him might as well be $500,000.
Well, let me ask a question about that. How much time, Madam Clerk, how much time does Mr. Wilhide have in? I would just do a credit time serve and resolve it, Your Honor, if that was okay with you. If not, then the ROR is fine.
All right, sir, Ms. Wilhide,
Yes, sir.
I didn't hear you. How much time does he have in?
2 days.
2 days, I think.
All right, 2 days. Ms. Wilhide, are you interested in entering a plea of guilty or no contest? If you were adjudicated guilty, there'd be mandatory court costs. There'd be 2 days and credit for the 2 days you served, and there'd be no return for 6 months to wherever it is that you were allegedly panhandling.
Yes, sir. I'll
Okay,
agree to
would you be
that.
interested in entering a plea
Yes.
of guilty if those were the terms?
Yes.
All right. What I'd like to do is have you read over a plea form. Can we furnish him one of those, please? Read this over. It talks about the rights you're giving up. Right? We won't be having a trial. It talks about some other rights, too. I'd have you take a look at that, and if you're agreeable, you can sign it, and we'll talk again in just a bit, okay?
Okay.
All right, thank you. Jeremy Winton. Hello, Mr. Winton.
Hello, Your Honor.
You're here as a result of two matters. One is a criminal charge, one is not. One is just a contempt matter. They allege you're in contempt by failing to pay child support. And there's a $1,000 purge which I'm going to leave in place and direct that you be brought before the Child Support Enforcement Magistrate, Linda Perez, at the Melbourne Courthouse tomorrow in the afternoon.
Your Honor.
Now, on the new charge, there's a charge of driving with a license suspended and driving without a vehicle that wasn't registered. Can you afford to hire an attorney to represent you?
Your Honor, I will be able to, but I would appreciate the public defender's help today in answering any questions.
Okay, did he fill out a financial affidavit?
No, sir.
Your Honor,
No?
I make too much money.
All right, well then, I find probable cause state. What's your position on the bonds here?
The schedule amounts, Your Honor.
Okay. Okay, what do you do for a living, Mr. Winton?
I'm a plumber, Your Honor,
How long have you lived in Brevard County?
since 1993.
Okay. Look, the $2,500, that's $250 to a bondsman. Why haven't you bonded out?
Because of the purge, she had to wait till this morning to be able to go to the courthouse to pay the $1,000 purge.
So you fully expect to be able to bond out on this, right?
Yes, sir.
Now, if you bond out, you need to appear tomorrow before the magistrate in Melbourne. Do you understand?
Okay. What time is that? Well, I guess it'll say on the paper.
1 o'clock in the afternoon. Linda Perez, 1 in the afternoon. Not here at the Moore Justice Center, but in Melbourne, the
Correct.
little courthouse in Melbourne, okay?
Yes, sir.
All right. Leave the purge amount in place, leave the bonds as they stand. Don't drive a motor vehicle without a valid driver's license. Appear for your next court date on June 25th as reflected in the paperwork I direct you to sign.
Thank you, Your Honor.
Thank you. With the,
I submitted his form.
Mr. Wilhite. Okay, very well, Mr. Wilhite, would you come on back up? One moment. Thank you. Mr. Wilhite,
Yes, sir.
do you swear or affirm that any testimony you give in this proceeding will be the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
What's your full name?
Robert Douglas Wilhide.
Ms. Wilhite, did you want to enter a plea of guilty on the charge, on the panhandling charge that we talked about earlier?
Yeah.
Has anyone promised you anything or threatened you with anything other than those terms that we outlined here in open court? Anything else?
No, sir.
Well, are you feeling pressured or coerced in any way to do this?
No.
Are you under the influence of any drugs or alcohol?
No.
Are you thinking clearly and using your best judgment?
Yes, sir.
Now, did you read that plea form carefully on both sides?
Yeah.
Did you sign it as well?
Yes, sir.
Do you understand all the rights you're giving up and all the consequences of entering the plea as set forth in the form?
Yes.
Giving up your right to a trial, we won't be having one. Do you understand?
Yes.
You understand how valuable a lawyer can be for you. And if you couldn't afford a lawyer, counsel would be appointed to represent you. Do you understand?
Yes.
You ever had a lawyer represent you?
Yes.
So you know what the role of a lawyer is, how valuable they can be, right?
Yes.
So you're consciously and intelligently giving up your right to a lawyer. Is that so?
Right. That's right.
All right. Now, do you understand that the charge you're entering, your guilty plea to, is a charge of panhandling? And you understand what that sort of activity is prohibited by this Melbourne ordinance?
Yes.
All right. But for the plea agreement, this would be punishable, I believe, by up to 60 days incarceration and a fine of up to $500. Do you have any questions?
No, sir.
Are you on any form of probation or community control?
What now?
Are you on probation?
No, sir.
Right now?
No.
The reason I'm asking is that if you're on probation, this could be a violation of your probation if you plead.
Yeah,
Do you
I know
understand?
that. Yes, sir.
Okay, all right. Very well. I find the plea freely and voluntarily entered with knowledge of its meaning and possible consequences upon a valid waiver of the defendant's right to an attorney. I find a factual basis from the sworn report and make the other findings indicate the form and accept the plea. There being no legal cause, I shouldn't go forward to adjudicate guilt, require you to pay the court costs, serve 2 days in Bryant County Jail, 2 days credit for time served, don't go to the location of the alleged panhandling for the next 6 months, and 6 months to make the payment. And you're advised you have 30 days when to appeal the judgment and sentence of the court. You're entitled to an attorney to assist you in that appeal. If you can't afford one, counsel would be appointed for appellate representation and dismiss the failure to appear. Okay?
Okay. Thank you.
Kara, does that dispose of it?
Yes, I just missed whether it was a no contest or guilty plea. I'm sorry.
Do you admit that you were panhandling there, sir?
Yeah, I'm through with that.
Okay, make it a guilty plea.
My social security starts.
All right, thank you. I wish you well. Good luck, Ms. Wilhide.
Thank you.
All right, I think that takes us through. There are 2 passes for the regional council, but I would like to take about 5 minutes.
Judge, I just want to make sure, did you withdraw the appointment of the public defender for Mr. Wilhite?
Oh, if I had not done so, I did withdraw that. Okay. He is not required to do a...
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.